The Senate Judiciary Committee will come to order. Welcome to the second half of the session. We now have House bills, and there are 4 blocks of House bills. I'm sorry, call the roll. Make sure we have a quorum.
A quorum is present, Mr. Chairman.
Okay, thank you. We have 4 blocks of House bills. The first block are bills that are uncontested in the House and the Senate, and that they are identical. And we'll go through one at a time and try to get them done in a block. The second, block 2, are contested bills that are identical. That is, they were contested in either the House or the Senate, but they are identical to bills that are in the Senate. And then the third block will be bills that are similar, and the staff will tell the difference between the House bills and the Senate bills. And then the fourth block is the regular agenda, which are new bills that we did not have identical or similar bills in the Senate. So, well, first of all, go ahead and start with block 1.
Mr. Chairman,
yes.
can I make a motion that we pass block 1 in a block?
Okay,
Report block 1 in a block.
Except for 275, that's right.
Well, let me go down each one so everybody understands what we're doing. The first one is House Bill 63, Myers, the Court of Appeals use of moot court rooms of accredited law schools, identical to Senate Bill 1002, DeSteff's bill. It's reported 15-0 in the Senate. The second bill is House Bill 256. And by the way, if anybody has any questions, please do not hesitate to say something. The second bill, 256, Mullins bill, disorderly conduct students, identical to Senate Bill 3, which is McClellan's bill, reported by the Senate Judiciary Committee 13-0. That third bill is House Bill 277, Price, payments of court fines and costs, community work in lieu of payment during imprisonment, identical to Senate Bill 736, which is open change bill, reported from the Judiciary Committee 12-0. The next one is House Bill 781, Mullins bill, accrual of cause of action, diagnosis of non-malignant and malignant asbestosis-related injury or disease, identical to Senate Bill 661, Senator Sherville's bill, reported 14-0. The next one is House Bill 1048, Krizik's bill, fingerprints and photographs by police authorities, identical to Senate Bill 925, Senator Peake's bill, reported 14-0 from the Senate. House Bill 1378, Lefwich's bill, signature defects on pleadings, motions, and other papers, identical to Senate Bill 229, Senator Peterson's bill, reported 15-0. The next one is House Bill 1605, Senator Delegate Hope's bill, partition of property, identical to Senate Bill 553, Senator Ruff's bill, reported 14-0. And then House Bill 275.
We're not doing 275.
Okay, all right, we'll stop there. All right. Those ones I just mentioned, they're 1, 2, 3, 4, 5, 6, 7. 2, 4, 6, 7 bills. Is there a
There was a motion and a second.
motion? And it's been seconded to report the bills in a block. All in favor of the motion, vote aye. All opposed, no.
Mr. Chair,
Ayes 11, no.
Ayes 11, no 0. The motion in a block is
Mr. Chair,
passed, yes.
Senate Bill 275, or House Bill 275 from Delegate Sullivan is identical to Senate Bill 209 from Senator Peterson. I move that we report and re-refer to the
Second.
Finance Committee.
Okay. House Bill 275 has been moved and seconded to report and re-refer to finance. Any discussion? All in favor of the motion, vote aye. All opposed, vote no.
Ayes 11, no 0.
11-0, the motion
Mr. Chair,
passes.
in Block 2, House Bill 61 from Delegate Collins is identical to Senate Bill 307 from Senator Stanley. It passed this committee on a 10-2 vote with Senators Obenshain and Stewart opposed. I'd move we report.
Second.
Okay, it's been moved and seconded that we report House Bill 61. Is there anybody like to say anything? All right, all in favor of the motion to report, vote aye. All opposed, no.
Ayes 11, noes 2.
Okay.
Mr. Chair, House Bill 305 from Delegate Hope is identical to Senator Favola's Senate Bill 940. It passed this committee with one negative vote from Senator Stanley. I'd move we report the bill.
Second.
It's been moved and seconded to report House Bill 305. Does anybody have anything to say? All in favor of the motion to report, vote aye. All opposed, vote no.
Ayes 12, noes 1.
Ayes 12, noes 1.
Miss-
The bill is reported.
Mr. Chair, House Bill 306 from Delegate Hope is identical to House Bill 938 from Senator Favola. It passed this committee on an 8-5 vote. And the makeup of the vote was pretty partisan in nature. I'd move that we report the bill.
Second.
House Bill 306 has been moved and seconded to report. Senator
Chairman,
McDougal.
I just want to note that some of us had some real concern because that money doesn't go to the clerks. It goes to somebody else, and that was the real concern about that bill.
Yeah, it goes to the library, I believe the state library. It's used to record and index the records of the circuit courts, but it goes to the library. Okay, any other discussion? Been moved and seconded to report Senate Bill 306. Vote aye. All in favor, vote aye. All opposed, vote no.
Ayes 8, noes 5.
Ayes 8, noes 5.
Surprise.
The
Okay,
bill
the
is
next
reported.
bill from Delegate Carol Foy, House Bill 366, is identical to Senator Servell's Senate Bill 72. I'd move that we report and re-refer the bill to Finance. It's the
Second.
bill that sets up a new public defender office in Prince William County.
Second.
It's been moved and seconded that this bill, Public Defender's Office in the cities of Manassas Park, and the county of Prince William. It's been moved and seconded that Senate Bill 366 be reported. All in favor, vote aye. All opposed, vote no.
Ayes 10, noes 2, 1 abstention.
Okay.
Okay, the next bill, House Bill 995 from Delegate Lindsay, is identical to Senator McClellan's Senate Bill 788, raising the felony threshold. I'd move we report.
Second.
Again, this was reported 8-5 from the Judiciary Committee before. Been moved and seconded that House Bill 995, raising the larceny threshold, be reported. All in favor, vote aye. All opposed, vote no.
Ayes 7, noes 6.
706.
Mr. Chair, the next bill is House Bill 1047 from Delegate Krasik. It's identical to Senate Bill 926, Senator Peak's bill that reported from this committee 12-2. I'd move we report the bill.
Second.
All right, it's been moved and seconded that House Bill 1047, fingerprints and photographs by police authorities, which passed the Senate this Judiciary Committee 12-2. All in favor of that motion to report, vote aye. All opposed, vote no.
Delegate Peterson, you voted against this bill before.
I will change your vote. All right,
Okay. All right, next.
The next
No, wait,
bill,
wait, we've got to report
12-1.
12-1.
okay, House Bill 1490 from Delegate Guy is identical to Senator Evans' Senate Bill 17. It has to do with
Same-sex marriages.
same-sex marriages. It passed this committee on a 9-5 vote. I would move to report.
Okay, it's been moved and seconded that Delegate Guy's House Bill 1490 dealing with same-sex marriages and civil unions, that it's been moved and seconded that bill be reported. All in favor, vote aye. All opposed, no.
Ayes 8, noes 5.
Ayes 8, noes 5, the bill is reported.
The next bill is House Bill 1561 from Delegate Mugler. It has to do with Fort Monroe Authority, civil actions to General District Court. It was identical to Senate Bill 956 from Senator Locke. It passed this committee on a 9-6 vote, and I would move to report.
Second.
All right, it's been moved and seconded to report House Bill 1561, Delegate Mugler's bill regarding Fort Monroe Authority, civil actions in General District Court. All in favor, vote aye. All opposed, vote no.
Ayes 6, noes 8.
Fails to report. It passed the Senate Judiciary Committee 9, Senator Locke's bill passed 9-6. Okay? It failed to report. Okay, is there, now, we're now going into,
People can change their minds, I guess. We're going to block 3,
If
Mr.
anybody
Chairman.
wants to move
The
to
the next
reconsider.
bill is House Bill 33 from.
Mr. Chair?
Delegate Peterson,
Well,
Senator Peterson.
No, let's go with Senator. Having voted on the prevailing side of House Bill 1561, I move to reconsider. If for no other reason, we can get the patron here.
Okay, and all in favor of the motion to reconsider, vote aye.
Aye.
Yes, say aye. No, we've got to vote aye, don't you? I'm sorry. All in favor, vote aye to reconsider. All opposed, no.
Mr. Chair,
Ayes 14, noes 0.
with the bill back before us, I'm not sure what we're going to learn from this, from the patron that we didn't learn from the last patron.
Let's hear, not everybody's here, it's one thing. Okay, Delegate Mugler?
Yes, sir.
All right, House Bill 1561, it passed the Judiciary Committee, Senator Locke's bill 9-6. Yours is identical, I believe.
Yes, my apologies. I was in another,
Not a problem. Welcome to the committee.
good afternoon. It's nice to see you. May I speak to the bill?
Yes.
House Bill 1561 is brought to us on behalf of the Fort Monroe Authority. Fort Monroe Authority is responsible for approximately 300 acres of land in coastal Virginia with over 1.5 million square feet of buildings. And the economic model for Fort Monroe includes the management and leasing of these facilities to private individuals. And although there are very few problems with tenants there, when a problem does occur, the authority would like to reserve the right to go to court. The Virginia Administrative Code allows business entities to prepare, execute, file, and serve in General District Court on a number of landlord and tenant-related filings. And since Fort Monroe Authority is not one of the business types listed in recent court hearing, their warrant and debt was dismissed. So incorporating Fort Monroe Authority into this existing statute would allow them to proceed in property management duties. So the legislative request is essentially to add Fort Monroe Authority to the list of entities such as the Department of Military Affairs, that many other pleadings and papers in court would save both Fort Monroe Authority and our state both time and money. It would be my request that this committee look favorably upon the bill.
Mr. Chair,
Yeah,
I
Senator
would
Dees.
just like to ask staff a question. This is identical to Senator Locke's bill that passed this committee on a 9-6 vote. Is that correct?
That's correct.
Yes, sir.
Okay.
Okay.
I
It's
second.
been moved and
Mr.
seconded to
Chairman.
report Senate Bill, House Bill
Senator Serville's got a
1561.
question.
Senator Serval.
Can I just want to remind everybody what the discussion was. I'm not sure much people were paying attention last time, but Senator Obenchain pointed out that we've tried to hold the line on non-attorneys filing pleadings in court, which is why I voted against it last time, and I'm voting against it again. But that's basically what the discussion was.
Okay, all right.
Mr. Chair,
Senator Peterson.
is there anything that prevents Fort Monroe from just going out and hiring an attorney to do their collection actions?
No, sir. Mr. Chair,
Yeah,
responding to the
yeah,
question.
Delegate Mugler.
So currently, Fort Monroe does not have that many issues with their tenants. And this would just allow them the opportunity to go forward when they needed to. You know, Fort Monroe Authority is owned by the state and by the National Park Service. So the state is actually funding any kind of legal fees that the authority would need to pay out. So this, in essence, would save the state some money.
Okay.
Mr. Chair,
Yeah, Senator McClellan.
Mr. Chair, we already crossed this Rubicon when we allowed the Department of Military Affairs to do it, and I don't see really any public policy reason that we would allow the Department of Military Affairs, but not the Fort Monroe Authority, when the Fort Monroe Authority is a state agency.
Okay, is there any further discussion? Yeah, Senator Morrissey.
Good afternoon, Delegate. I agree with Senator McClellan that we've crossed this Rubicon before. but do you see an end to this where authorities or other entities can prepare these documents? And do you see a potential problem that we're now creating a sort of madness for clerks' offices that normally would handle this, and we now have different entities that aren't represented by attorneys filing these documents?
Delegate Mugler.
Mr. Chair, speaking to the question, I'm speaking specifically on behalf of Fort Monroe Authority. It is an unusual authority. And so, can I say that it would not open up floodgates? I can't guarantee you that it would not. But I believe that given the unique nature of Fort Monroe Authority and where it gains its funding, that it makes good sense for us to allow this.
You've already reported the bill.
Follow-up question, Mr. Chair.
Maybe lock up the same.
Yeah, Senator Morrissey?
Thank you. Who would be the person to file this document?
Mr. Chair, speaking to the question.
Yes, go ahead.
Fort Monroe Authority has about 25 employees, so I don't know exactly which individual. Executive Director Glenn Oder, generally handles all the executive aspects of things, and I believe they have one individual who handles the property aspects of the authority, and that individual would be going forward. I don't know the individual's name.
Senator Overchain.
Mr. Chairman, am I correct that we've got a list of these bills in front of us with a list of the companion bills that came out of this
This
chamber?
is Senate Bill 956 that passed this body
Am I
9
correct,
to 6.
Mr. Chairman, that it lists how each individual member voted last time?
Exactly.
So, and that this bill passed out 9 to 6?
That's correct.
And while I might not like it, it might be on its way to passage in the House no matter what we do with this bill.
That's correct. Is there any further discussion? Is there a motion has been made to report, made and second to report House Bill 1561. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 806.
8 to 6.
John?
The bill is reported. Yes, Senator
Richard's a
Overchain?
no.
Yes, thank you.
Mr. Chair, we're in the block 3 now. These bills are
Thank you.
similar to the bills we've already passed, but they're not identical. The first one we have to look at is House Bill 33 from Delegate Lindsay. It's similar to Senate Bill 793 from Senator McClellan. Now, Delegate Lindsay told me he was okay with conforming the bill, but I'd like to hear from staff as to whether or not they've got the better version or we've got the better
Well, is
version.
Delegate Lindsay here? Or?
Well, he was here, and I told him we could
All right.
probably handle this
Okay, the
without him.
staff will explain the difference between House Bill 33 and Senate Bill 793 from Senator
Is there any
McClellan.
reason not to conform?
Mr.
Just
Chair,
listen to the distinction.
the distinction is that 793 applies to a broader category of offenses and includes the provisions regarding when parole interviews should be scheduled.
Okay.
So there's no reason not to conform.
Move to conform and report.
It's been moved and seconded to report, to conform House Bill 33 to Senate Bill 703. All in favor of the motion to conform, vote aye. I think we have to vote aye. Yeah,
Adopt the amendment.
What,
The
the-
amendment would conform
This-
this bill to Senator McClellan's. So
All right,
I
yeah,
move that
the-
we create a substitute.
Yeah, the amendment is to conform Senate Bill, House Bill 33 to Senate Bill 793. All in favor, it's been moved and seconded. All in favor of the motion to conform, vote aye.
Say aye.
You want to vote?
Now move to report.
Well, we have a substitute, okay. It's been moved and seconded to report the substitute. All in favor of the motion, vote aye. All opposed, no.
Ayes 1500.
15-0.
Okay, the next bill
ahead.
is House Bill 35 from Delegate Lindsay. It's similar to Senate Bill 103, and unless there's some technical reason why we shouldn't conform, I would move that we conform it.
Well, let's hear the difference.
Mr. Chair, in this bill, the differences are largely editorial, but there is a cross-reference in House Bill 35 that is drawn correctly, which is incorrect on Senate Bill 103. So I would not recommend conforming this bill.
Okay, I move we report the bill.
Not recommend conforming,
What I mean is just keep the bill in the current form.
all right. Okay, anybody want to explain House Bill 35? Yeah, staff, would you like to explain it?
So this is the juvenile parole bill. This just provides that a juvenile who has been sentenced to a term of imprisonment for a single offense or multiple felony offenses, who has served at least 20 years, would be eligible for parole.
Okay. Is there?
This is not fishback. This is the juvenile parole. This is for juveniles who've been sentenced, and in light of the Supreme Court cases dealing with juveniles having some meaningful release, this is what.
Similar to Senate Bill 103 of Senator Marsden, and it would pass the Judiciary Committee 11-2. All right, it's been moved and seconded to report House Bill 35. All in favor, vote aye. All opposed, vote no.
Ayes 12, noes 3.
Okay, the next bill, Mr. Chair, is House Bill 100 from Delegate Lindsay. That's identical to a Senate bill that I carried that passed from this. Similar.
Okay, is there a difference, Jeff?
Yes, Mr. Chair, there is a difference. House Bill 100 merely is limited to informing the juror of the potential range of punishment. Senator Deeds' Senate Bill 325 contained more descriptive information as to what could be inquired in voir dire. So it would, I think the body would want to conform House Bill 100 into Senator
Then
Deeds'
I
bill.
move we create a substitute which conforms to Senate Bill 325.
Okay, House Bill 100 would be rolled in or conform to Senate Bill 325, and it'd be a substitute. And we have to vote on this, don't we?
Ayes and nays.
All right, all in favor of the motion, vote aye.
Aye.
Say aye. All in favor, say aye. All opposed, no. Motion carries.
Okay, I move we report the substitute for House Bill 100.
It's been moved. Is there a second? Seconded.
There was a second.
That we report the substitute to House Bill 100. All in favor of the motion, vote aye. All opposed, vote no. Okay,
Ayes 15, no 0.
15-0. All
Okay,
right,
House Bill 136 is similar to Senator Marsden's 294. It passed this committee on a 9-5 vote. It deals with the deposit for surrender of principal for reasons other than principal's failure to appear on a bail bondsman. As I said, it passed this committee on a 9-5 vote. I'd move we report the bill.
yeah, Senate Bill 294, Marston.
Oh, wait. Are there differences?
What is the difference?
Mr. Chair, the differences are largely editorial. For example, Senator Marsden uses the word principal. Delegate Collins in his bill uses the word payer. I would recommend that we just conform the bill, and the bills can be
I
resolved
move
in
we
Congress.
create a substitute and conform this bill to
Second.
Senate Bill 294.
I moved and seconded that we have a substitute to 130, House Bill 136 that would look just like Senate Bill 294. All in favor of that motion, say aye. Aye. All opposed, no.
Move to report the substitute.
Motion carries. All right, now the motion is made to, and seconded to report the substitute to House Bill 136. Moved and seconded, right?
Moved and seconded.
All in favor of the motion, vote aye. All opposed, vote no.
Ayes 11, noes 4.
11-4, the motion carries.
The next bill is House Bill 259, Senate Delegate Simon's bill about an unrestorably incompetent defendant, about the competency report. It's similar to Senate Bill 670 from Senator Mason that reported from this committee 15-0.
Okay, all right. Okay, go ahead, Senator Dees.
So the similar bill passed this committee 15-0, and I'd ask staff to explain if there's a difference worth considering.
Mr. Chair, the differences are largely technical. In Senator Mason's bill, it does contain some conditions that reflect what would be unrestorably incompetent, where in Delegate Simon's bill, it basically just refers to the defendant as being unrestorably incompetent and likely to remain for the foreseeable future.
Mr. Chair, I move that we make a substitute to incorporate.
All right, the motion's been made to have it create a substitute to House Bill 259 to look like Senate Bill 670.
That motion and second, just as a
All in
name.
favor of the motion, say aye. Aye. All opposed, no.
I move we report the
Motion-
substitute.
Motion carries. All right. Now, motion's been made and seconded to report the substitute to 259. Okay. All in favor of the motion, vote aye. All opposed, vote no.
15, no, 0.
Okay.
Okay.
Go ahead.
Sorry,
Yeah,
Mr.
I'm sorry, go ahead.
The next bill is Senate Delegate Sullivan's House Bill 276, dealing with reporting hate crimes. It's similar to part of Senate Bill 179 from Senator Favola that reported from this committee 8-3. And I'd ask staff to explain the difference.
So this is, as Senator Deeds just mentioned, part of Senate 179 from Senator Favola, her hate crimes bill. This bill from Delegate Sullivan just requires the reporting of hate crimes to state police. In Senator Favola's bill, we included a definition for disability, which this committee has always struggled with finding that definition. So I would recommend that the HB 276 conform to that part of Senator Favola's bill.
And I would so
Just
move.
that part of the bill.
I would so move.
All right, is all in favor of the substitute to House Bill 276, so it looks just like Senate Bill 179? All in favor of that motion, say aye. Aye. All opposed, no? I think it passed.
Yeah, I think so. Are you all right?
It passed on a voice vote. Huh? Yeah,
Report the substitute,
now we
yes.
have to report the substitute. All in favor of the substitute to House Bill
You voted
276?
against the bill anyway.
All in favor of the substitute to House Bill 276, is there a motion?
So moved.
Is there a second?
Second.
All right, second. All in favor of the motion to report the substitute to House Bill 276, Delegate Sullivan's bill, vote aye. All opposed, no.
Ayes 10, noes 5.
10-5, the
Mis-
motion carries.
Mr. Chair, the next bill, HB 477 from Delegate Guzman, deals with trying juveniles as adults. It's similar to your Senate Bill 746. It reported from this committee 9-4, and I'd ask staff to explain the differences.
Mr. Chair, House Bill 477 is similar to your Senate Bill 546. House Bill 477 contains a provision which requires the director of the Court Services Unit in Juvenile and Domestic Relations Court to complete a report before proceeding with a preliminary hearing. And it also does not contain a cross-reference to the confidentiality of the juvenile law enforcement records section, which your bill does. So I would recommend that this bill be conformed to your bill.
And I'd so move that we create that substitute.
Okay, all in favor of creating the substitute to House Bill 477 to look like my bill, Senate Bill 546? All in favor of that motion, vote aye. 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 All opposed, no? No.
Just been informed patrons on the way down to speak on the bill.
3-0. It's all right. Move we report the substitute.
Okay, it's been moved and seconded to report the substitute to House Bill 477. All in favor of the motion, vote aye. All opposed, no.
Ayes 12, noes 3.
12-3, the motion carries.
Okay, the next bill, Mr. Chairman, is House Bill 752 from Delegate Jones. It's similar to Senate Bill 312 from Senator Stanley, which reported from this committee 13-0. And I would ask staff to explain the differences.
The main differences between House Bill 752 and Senate Bill 312 is House Bill 752 does amend some other sections to try and make the language more consistent throughout the code. But in talking with the patron before the meeting, he'd like to just conform his bill to Senator Stanley's Senate Bill 312.
I'd move we conform, create a substitute, yes.
All right, is there a second? Second. All in favor of the motion to create a substitute to House Bill 752 to look identical to Senator Stanley's Senate Bill 312? All in favor of that motion, vote aye.
Aye.
All opposed?
Move to report the
Hold on,
substitute.
can we, Mr. Chair?
The motion carries.
Mr. Chair.
Yes, Senator, Peterson.
Before we report this bill, and I know we had a version of this on the pre-crossover, what exactly does post-release incarceration mean? What is that referring to?
Mr. Chair, to answer Senator Peterson's questions, after a defendant has been convicted or while he's being sentenced, the court will impose a 6-month period of what I would call post-release supervision. In other words, after the defendant has complied and with his prison term, if one's been ordered, he does remain under court supervision for an additional 6 months. The language change was to reflect that if the individual violates some condition during those 6 months, that he could be incarcerated for that violation, because the current language just reflects a post-release supervision, and the court may lack the authority to incarcerate the person.
All right, look, can I ask a follow-up question, Mr. Chair? Okay, so if I look at this bill, I may be looking at the House version and not the conform version, but it talks about an added term of, it says the court shall impose an added term of post-release, and it strikes supervision and adds incarceration. I never construe the word shall to mean discretion. I construe that to be mandatory.
Mr. Chair, I would tell Senator Peterson that I believe you are looking at the House version and not the Senate version. Right. And I believe the House version was attempting to address the issue that these 6 months provision, these additional 6 months could raise the term to be over the statutory maximum. So if someone was to be sentenced on a Class 6 felony to 5 years, the court would then impose an additional 6 months of supervised release or 6 months of potential incarceration in addition to those 5 years. That is the current practice, and this is what the bill, as Senator Stanley's introduced and this body has acted favorably on, is to reflect the current procedure for those defendants under his bill.
Okay. Any
I
further?
see, Senator.
I'm not quite sure.
Senator Peterson.
Well, Stanley's bill reflects the current practice. Why do we even need Stanley's bill? But
Mr. Chair and Senator Peterson, I think the need for Senator Stanley's bill, and this was coming from the Judicial Council and I believe the Committee on District Courts, was to change the words of supervised or post-release supervision to post-release incarceration, because the term supervision did not allow for a sentence to be imposed or for an incarceration to be, a term of incarceration to be imposed.
Any further questions? Does somebody want to speak on the bill?
Mr. Chairman, Mike Doucette, Executive Director of the Virginia Association of Commonwealth Attorneys. This bill is drawn to a narrow aspect of the law where we have either a mandatory minimum sentence or whether the jury has imposed a sentence and the judge has gone forward with that particular sentence and says that there is no suspended period of time. And so, for instance, if a person is charged with possession of a firearm as a violent felon, the sentence is 5 years. And this body, probably 20, 25 years ago, thought that there ought to be some period of supervision afterwards. And so as a result of that, even though the most you can give was 5 years, the only thing you could give was 5 years. But they needed some supervision afterwards. You couldn't suspend any of that 5 years. They needed that supervision. The confusion came up, it's come up a number of times, is how do you give someone an additional period of supervision? What is the period that is being revoked? There was a case out of the Virginia Supreme Court in 2018 called Thomas versus Commonwealth, in which the jury came down with a 7-year sentence. The judge imposed the 7-year sentence, but then said, there needs to be some supervision. So the judge wound up sentencing him to 10 years actually it was her, sentenced her to 10 years, and then suspended 3 years, so there was some supervision afterwards. Went up to the Supreme Court of Virginia. The Supreme Court says, no, 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 you cannot give more than the jury gave. So what you need to do is you need to refer to this code section 19.2-295.2 and give them an additional period of incarceration that shall be suspended. And then that is the portion that is.
The more I hear about this bill, the less I like it, so I don't know, maybe you might be talking
This is
yourself about it.
this is a creation from the General Assembly about 25 years ago.
Oh, that's probably a bad idea then, okay.
All right, this bill has now been conformed to Senator
Mr. Chairman, can we take this
Stanley's-
bill by temporary so the patron can get here?
All right, Delegate Jones, all right. Is Delegate Jones here? He left. All right, okay, we'll go by temporarily.
House Bill 792 from Delegate Simons. Delegate Simon deals with appeals of right in General District Court. It's similar to your bill, Mr. Chairman. Your bill, 545, it reported from this committee 10-5, and I'd ask staff about the differences.
Mr. Chairman, this is the piggyback bill that we largely scaled down in Judiciary. And your bill, Senate Bill 545, reported out with a substitute that provides that any appeal of right taken from a court not of record shall serve as an appeal of all claims in that lower court, and I would recommend we conform them.
What is the current version of 792?
792 is the bill that came out of Boyd Graves, and there's the 5-day rule.
All right, okay.
So I'd move we conform.
All right, it's been moved and seconded that we conform House Bill 792 to the bill, Senate Bill 545. Moved and seconded to that. All in
Yes.
favor of the motion, say aye.
Aye.
All opposed, no. There's a motion.
Motion to report.
Motioned and moved and seconded to report the substitute to House Bill 792. All in favor of that motion, vote aye. All opposed, no.
Ayes 13, noes 1.
13-1.
Okay, the next bill, Mr. Chair, is House Bill 861 from Delegate Levine. It deals with the best interest of the child, active violence, force, threat against the intimate partner or the intimate partner's child. It's similar to Senate Bill 105 from Delegate Favola, or Senator Favola, that reported from this committee 12-0.
Okay.
Mr. Chairman, in
Yeah.
Senator Favola's bill, we removed the language related to acts of violence, force, or threat against an intimate partner and intimate partner's child, and we just considered the history of any child abuse.
Okay.
So I would recommend we conform.
Mr. Chair, then I move that we create a substitute conforming this bill to Senate Bill 105.
Okay, it's a motion has been made and seconded to conform, to create a substitute for House Bill 861 to look like Senate Bill 105. All in favor of that motion, say aye.
Aye.
Aye. All opposed, no. Motion carries.
Then I move to report the substitute.
Been moved and seconded that the substitute to House Bill 861 of Delegate Levine be reported. All in favor, vote aye. All opposed, no.
Ayes 15, no 0.
15-0.
Mr. Chair, do you want me to finish this block and then go back to Delegate Jones? or you want
Yeah,
to-
let's go ahead and finish the block.
Okay, Delegate, House Bill 1023 from Delegate Adams deals with recording custodial interrogations. It's similar to Senate Bill 730 from Senator McClellan. It reported from this committee 11-02, 2 abstentions. And I'd ask staff about the differences.
Differences.
Mr. Chair, the main differences between House Bill 1023 and Senator McClellan's Senate Bill 730 deals with the phrase in its entirety. This committee made the addition of it in its entirety in one spot of the bill. The House decided to add it in a few more locations. I'd recommend that we conform it to the Senate version.
Okay, is there a motion to conform, to create a substitute?
So moved.
Conforming House Bill 1023 to Senate Bill 730, McClellan's bill. Is there a second?
Mr. Chairman,
Yeah. Yes, go ahead.
we're on HB 1023, aren't we?
Yeah, we're on
I have a question.
1023. To conform it to Senator McClellan 730.
Put the brakes on for just a moment. Let me ask staff.
Go ahead.
If I understand correctly, House Bill 1023 adds additional language than language that came out of this committee and uses the words in its entirety. Is that correct?
Mr. Chair, to answer Senator Morris's question, the House version used the phrase that this committee adopted and put it in more locations in the bill. I don't believe that the addition of its entirety necessarily changes what this committee did.
Further question?
Yeah, Senator Morrissey.
And again, to staff, should we add the language, the phrase in its entirety to our version, given that the House version used it in more locations? Or another way of asking that is, if we conform House bill to our bill, are we then limiting the number, the times where in its entirety is used?
Mr. Chair, I believe Mr. Benjamin, when he made the amendment on Senate Bill 30, did so in a more surgical manner than the House may have made it.
Mr. Chair.
Okay, Senator McClellan.
Thank you, Mr. Chair. This was a bill that was a recommendation of the Virginia Criminal Justice Conference after, about a year of looking at it. And so my question for the House patron is whether VCJC was okay with your amendment?
Okay, Delegate Adams.
Thank you, Mr. Chairman. Senator McClellan, yes, there was no objection, and I would agree with counsel to the extent that I think maybe in some ways is redundant, but the will of the committee was to ensure that the recording was for the entirety of the conference, of the custodial interrogation.
And I see the representative here. Do you have a preference?
Yes, Mr. Chairman, Senator McClellan, in the House, they were just a little more belt and suspenders with their use of during the entirety of than they were in the Senate version. But I think the net result is the same and does reflect VCJC's intent.
Mr. Chair.
Okay, Senator Peterson.
Yeah, so and I know we went through a version of this on our side, but it says that the failure to make an audiovisual recording of the statement would not make it inadmissible, but it goes to the weight of the evidence.
That is correct, Senator Peterson.
So basically, if you tape my client and then if you question my client, but then you don't make a tape of that, and then of course you're going to use the transcript against him as a statement by a party, I mean, how exactly am I supposed to rebut that? Am I supposed to say, well, you were supposed to record that, and you're like, well, I didn't, and then we just go on? I mean, what's the purpose of having the statute if it's not going to be inadmissible?
Mr. Chairman, Senator Peterson, that's our world. I mean, that's the reality of criminal procedure.
Okay. All right, Delegate Senator Morrissey.
Here's the issue. We all agree that the entirety of that custodial interrogation needs to be preserved. Here's what we're down to. Do we like the House version because it uses, as you referred to, the suspenders and belts more frequently, in its entirety, or do we like our version? I tend to like the House version because it uses more belts and more suspenders, and it uses the phrase in its entirety more. That's why, Mr. Chairman, I have problem conforming the House bill to ours. I like theirs better. I may be the only one here that does.
Okay.
Mr. Chair?
Yeah, Delegate Senator McClellan.
I'm indifferent. Whatever the committee wants to do, if you want to keep the House version the way that it is, then I'll conform mine to this one when it's in the House.
All right, is there a motion to just report House Bill 1023 and not conform it?
Mr. Chair, I rather than go on the fly, I would rather put the bill in conference so somebody's going to look at it if.
It's fine.
Yeah, Mr. Chairman, there may be a problem here because as a current, let's say that they start to record the entirety through audiovisual means and then it breaks. They would then switch over to
audio recording.
Yeah, just audio recording. But if we have it in each place, then I'm afraid that would prohibit the alternative method. So the belt and suspenders wording may actually create a problem or have a consequence that we don't intend. That's my concern.
For that reason, I'd like to conform this bill to the Senate bill, and then that gives us at least another week or so to think about the differences.
All right, it's been moved. Is there a second? It's moved and seconded to conform House Bill 1023 to Senator McClellan, Senate Bill 730. All in favor of the motion, say aye. Aye. All opposed, no.
Move to report the bill as substitute form
It's been
and re-refer to
It's been
finance.
moved and seconded to report the substitute to House Bill 1023 and to re-refer it to the Senate Finance Committee. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no zero.
15-0.
Okay, the next bill, Mr. Chair, is House Bill 1150 from Delegate Lopez, involves inquiry and reporting of immigration status, persons convicted, charged or convicted of certain crimes. It's similar to Senator Servel's 491 that passed out of this committee on an 8-3 vote, and I'd ask staff to help us with the differences.
Mr. Chair, House Bill 1150 was identical to Senate Bill 491, which reported out of this committee, and Senator Serval offered a floor substitute, which passed the Senate, which I believe was to address some problems in New York. The main differences obviously are in Senate Bill 491 as it passed the Senate. It was confined to felony offenses that allowed the disclosures or the inquiries to be made, where House Bill 1150 basically removes all those provisions. So it'd be my recommendation to conform it to Senate Bill 491.
I move that we conform it, make this a substitute for Senate Bill 491. or Senate
All
Bill
in favor of the motion to create a substitute for House Bill 1150 by conforming it to Senate Bill 491. All in favor of that motion, say aye.
Aye.
All opposed, no. Motion carries.
Move to report the substitute.
It's been moved and seconded that the report to House Bill 1150 of Senator Lopez's be reported. All in favor, is it moved, it's been moved and seconded for that? Is there a motion?
Yes.
And
So
a
moved.
second. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 10, noes 5.
Motion carries 10-5.
The last bill in this block, and I understand we've got Delegate Jones. Well, no, you're next, and then we're going to have to take another bill, bring it back. But the last bill on the list is House Bill 1213 from Delegate Heretic. It deals with authority of local government employees to issue summonses for violations of local ordinances. It's similar to Senate Bill 396 from Senator Kiggins that failed to report from this committee by a vote of five yeas and 8 nays.
All right.
I'd ask staff to help us with that.
Mr. Chair, since this bill failed to report from the committee, I would defer to the patron to explain the bill. He may want to offer some alternative language than the bill that currently exists.
Okay, Delegate Heretic, House Bill 1213.
Mr. Chairman, thank you.
Mr. Chairman, before he starts, I know Senator Serval had talked to me because since this happened, a number of people have been trying to see if we could come up with a solution to that. And I don't know if Senator Serval we'd fully formed in that thought process. Did you want to try to bring that up today?
Yeah,
Or do you
Mr.
want to
Chairman.
see if we can, because I think some of us believe it is what they're
Okay.
trying to do is a laudable goal. It's just whether we can make the words work to
We have an
do what they want to
amendment
do.
here in the nature of a substitute to House Bill 1213. Is there a motion to adopt the substitute?
So moved.
Is there a second? Second. All in favor of the motion, say aye.
Aye.
All opposed, no. Motion carries.
Mr.
Okay,
Chairman.
Delegate Heretic, yes.
Mr. Chairman.
Senator Serval.
Yeah, this substitute reflects the concept that I articulated to Senator McDougal and also to some representatives from the city of Norfolk who came to see me. I have not talked with Delegate Heretic about it, but
Okay.
I thought it'd be easier to achieve this by saying what they could not enforce as opposed to trying to articulate what they could
Okay,
enforce.
Delegate Heretic, do you want to explain it, or Thelma Drake?
Basically,
You're
Mr.
a
Chairman.
lawyer there, Thelma Drake, would you like it? Go ahead.
Go right ahead.
Go
Thank you,
ahead.
Delegate Heretic. Mr. Chairman, members of the committee, this is simply putting back into place what local governments had prior to 2014, authorizing them to issue summonses for things like building code, zoning violations, wetlands violations. We do really appreciate your work on this because we weren't trying to expand it beyond the sort of things. In Norfolk, we prefer that our employees issue that summons. They have no other authority. If there's any issue or need to be arrested, they do bring a police officer with them. Right now, these employees have to do a law enforcement school and be licensed every 2 years because what happened in 2014, I think, was aimed at people acting as law enforcement. But this sentence and a half out of the bill in 2014 removed the authority that localities had to issue these summonses.
Mr.
I
Chair.
appreciate the work.
Okay,
Mr.
Senator
Chair.
Peterson.
So I think, Thelma, that basically what we've done is the locality can have the power to issue a summons to enforce a local ordinance or misdemeanors, but nothing that would either impact 18.2 or 46.2 in the code.
Yes, thank you. Thank you, Senator.
Okay, is there any further discussion?
Mr. Chairman.
Yes, Senator,
Speaking to the bill, I think that also, council, for this language to be clear, it's not just offenses listed in those, but it's also local ordinances that are substantially similar to it, or, because localities often adopt parallel ordinances, and it needs to be clear that we're talking about those too.
Mr. Chair, I believe that's correct. That would be a friendly amendment to
any
it.
further discussion? Is there a motion?
Mr. Chairman, there's another technical
Steve
correction.
Benjamin.
On line 15, after the word ordinances. No, I'm sorry. Yeah, after the first appearance of the word ordinances on line 15, insert the words within the scope of their employment. And then at the end of that sentence, a comma after the word ordinances. Then strike on line 16 the words that are within the scope of the employee's employment, and substitute the word except for the word excluding.
That amendment.
So you're striking, now, after the word ordinance on 15, you're putting in the language within the scope of the employee's employment? Is that
Of
it?
their employment.
Of their employment, all right. And that would be between ordinances and by on line
Yes.
15. Strike within the scope of the employee's employment on 16 and add the word except and exclude.
And strike the
delete
word excluding.
Okay? Everybody understand that? Is there a motion to that effect? Line item,
Yes.
is there, been moved and seconded to adopt the line item amendment to the substitute. All in favor of the motion, say aye. Aye. All opposed, no? Okay. Okay, Steve, would you like to explain the bill any further?
Senator, I think you have it.
I think you're in good shape. Okay, is there a motion that we
Mr.
adopt?
Chairman, did we make
the
my amendment to make sure that the local ordinances paralleling 18.2 and 46.2 are in?
Well, that's part of the substitutes. Is it not?
Substantially similar language.
I think
It's not in there. That's why I just asked. I asked, we amended, and I made a motion, and Mr. Chairman, I think you thought I was moving to report. I wanted to make sure that,
Mr. Chair, I believe Senator Serval brought this up and asked if it would be a friendly amendment, and I agreed in the affirmative that it would be a friendly amendment.
and nobody made a
Mr.
motion.
Chair, Mr. Chair.
Is there a motion? Yes,
Mr. Chair.
Senator Peterson.
I think you can do it by on line 17, after title 46.2, just say, and those local ordinances which are substantially similar.
Is that a motion? All right.
I make that a motion.
Second.
Is it moved and seconded to add in those local ordinances that
Which
are
are
substantially
substantially
similar?
similar.
Let's get one person speaking at a time. Those local ordinances that are substantially similar.
Right.
And that would be after 18.
46.2. After 46.2.
And that's on line 17, okay. At the end of the sentence, right? Okay. Any further discussion on that motion to adopt that line amendment? All in favor of the line amendment, vote aye. Say aye. Aye. All opposed, no. Motion carries. Okay, we've carved it up pretty well.
Thank you. Thank you, Mr. Chairman.
Is there a motion that the substitute as amended be adopted? Is there a motion? It's been moved. Is there a second? It's been moved and seconded that the substitute to House Bill 1213 as amended be reported. Is there a motion that be reported? All in favor, vote aye. All opposed, no.
It's 15-0.
15-0. Well, congratulations.
Okay, Mr. Chair, let's go back to House Bill 752 from Delegate Jones. He's here now.
Okay,
I'm
Delegate
back.
Jones, welcome.
Good afternoon, Mr. Chairman.
You're welcome.
Mr. Chairman, if I could briefly explain the bill and sort of try to clear up some confusion, I'm happy to do that.
Senate Bill 752. Okay?
Mr. Chairman, members of the committee, House Bill 752 is a bill that's designed to really clean up some language that's in the code that was enacted several years ago, and then new code was enacted years later, but the language was not together. Senator Stanley had this bill, but I'll sort of briefly explain to you that the purpose of the statute is to require that the court impose a term of post-release incarceration upon conviction of a failure to register for the sex offender that will go into effect if the defendant fails to abide by the terms and conditions of their post-release supervision. But as currently written, the references to post-release supervision are there by themselves, so you can't impose post-release supervision while also suspending a term of incarceration. You've got to have the supervision and then impose the incarceration. So in the statute, you've got a situation in which the statute prescribes post-release supervision, but that shall be suspended while simultaneously placing the defendant on supervision. And so we're changing the words across a couple of statutes to incarceration so that they're not in conflict. Supervision, incarceration, and conflict. So that's what this is doing. I think there was some confusion and some with Senator Peterson.
And it's confusion that's sort of morphing into objection. And here's the objection, and that is we have the class of sex offenders that we have all sorts of requirements upon them to give us every time they move, every time they change their bank code, every time they do this, every time they do that. And I see something that says mandatory post-release incarceration for an additional 2 years for what could be a technical violation, what could be something that just not. So I guess I don't like the substance of the bill. I'm not blaming you, and this is a law that obviously dates back to the 90s, but this is a substantive objection.
So Senator Peterson, Mr. Chairman, I would say I think you are drawing a distinction between what the law actually says, and I'm inclined to agree with you as to what we make these folks do. I think what the bill is seeking to do is not to impose any additional time or take anything out of what they're supposed to do already. We're trying to sort of make some language consistent across several code sections. I think there was an oversight several years ago.
Mr. Chair.
Yes, Senator Peterson.
Right now, the word says supervision. We're changing that to incarceration. Now, granted, I may have just gone to Fairfax High School, but that to me is a substantive change. And as a substantive change, I don't necessarily agree with. Now, you say maybe we're cleaning up language. Supervision to incarceration is more than just cleaning up language. That to me is a moral choice about what we're doing with somebody.
Mr. Chairman, I would defer to Ms. Longenecker if that's okay, because I think she might be able to properly explain.
Eileen Longenecker with OES at the Supreme Court. The issue is that judges currently are interpreting the word supervision as supervision and also incarceration, because you can't have one without the other. There was an error made in another statute years ago. And then this statute was created after that error was made in the other statute, modeled after that statute. So right now, the judges are ordering post-release supervision and post-release incarceration. Post-release supervision is nonsensical without incarceration. All we're trying to do with this bill is to correct a term. But the judges are currently ordering post-release supervision with post-release incarceration because it's nonsensical if they don't do it that way.
Should it be parole or something like that, or probation rather than supervision? Because if post-release means you're out of prison, which is not the same as incarceration.
This is you're on supervision, and if you do something you're not supposed to, then the post-release incarceration is hanging over your head. So the way the judges are doing the orders now, they're interpreting supervision, post-release supervision, to mean ordering post-release supervision and ordering post-release incarceration. The orders will get kicked back from the parole board and DOC if they don't order it that way. So we're simply trying to correct an error in the statute.
Isn't there a contradiction between post-release and incarceration? Incarceration means you're in prison. What am I missing here? Post-release means you're out.
It's post-release incarceration, so that while you're on supervision,
It's like, that's an oxymoron, isn't it? Post-release incarceration.
it's current law.
Mr. Chair, and
Help me, Joe.
This,
My personal attorney over here.
Okay.
on the House version, if you go to lines 88, starting with failure, this is, I think, the whole problem with the current wording. It says that failure to successfully abide by the terms and conditions of the post-release supervision program shall be grounds to terminate the period of post-release supervision and recommit the defendant to the Department of Corrections or to a local correctional facility. If you're recommitting them and they're just on supervision, there's no way, there's nothing to recommit them to. I mean, that's the problem, and that's existing language in the statute.
Mr. Chair.
Yeah, we've taken care of this bill.
I need my attorney.
Mr. Chairman?
Yeah, Senator,
Morrissey.
Where's Stanley?
I'm sorry, ma'am, what's your last name?
Longenecker?
Longenecker? All right. If I understood you correctly, you said that judges are interpreting post-release supervision to mean post-release supervision and/or incarceration.
With and, not or, with.
With. But that's the judge's interpretation. It's not the General Assembly's
It's
interpretation.
the
Is that correct?
I don't think so. There's case law that says, and I believe Mr. Doucette mentioned the Williams case, there's case law that says you can't order post-release supervision without post-release incarceration. It's been interpreted by the courts that way because otherwise it's nonsensical. The sentence as written on lines 27 through 30, the bill is introduced, says the judge shall order that post-release supervision be suspended and then the defendant be placed on active supervision under post-release supervision. The sentence is simply nonsensical the way it's written. And case law has interpreted the term post-release supervision to mean supervision and incarceration.
Follow-up question.
Yeah,
And Mr. Benjamin, maybe you can make sure we're not speaking over each other. Normally, the judges will sentence an individual to a period of incarceration. They will suspend a portion of that. If the defendant then violates, when he's released, by not registering with SOR, right, the judge can reincarcerate him, but the period that he can do it is limited to the amount of time that he had a previous suspended sentence or any new offense that he was convicted of for not abiding by the SOR registry. Am I right?
That's right, but I don't think that's current. One of the better examples given previously was if a person is sentenced to a mandatory minimum of 5 years. You can't suspend any portion of that. And so the genesis of this statutory framework was to provide for a supervision period of, say, at least 6 months. The problem is that when it was enacted, they used the wrong word. They said, shall impose an additional 6 months of supervision. And if they violate that supervision, then you'll terminate the period of supervision and be recommitted to DOC. The question one member of the committee asked a moment ago it drives the point home. How can you recommit somebody to a period of incarceration that doesn't exist? It appears to me, though, that the courts have solved that problem by reading the statute to imply that a period of incarceration is meant.
Mr. Chairman, that's exactly the point. Yes. The courts have done this, not us. And so I'm almost done. The courts have said that we're going to interpret that additional period of supervision to mean incarceration. We haven't said that, and unless and until we say that, the courts shouldn't be doing that.
That's, if I may add, that's
one at a time. Go ahead, speak.
That's the situation currently under 19.2, 95.2, which actually has 2 sentences that are the same. It says the court shall do supervision, post-release supervision for 6 months. This is in the substitute, the House substitute.
Are you on line 51?
I am, shall do post-release supervision for a period of 6 months to 3 years. And then down on line 55, it talks about the supervision shall be for a period of 6 months to 3 years. It's the same sentence twice because the error was originally made in 19.2 to 95.2. And so then this other statute, 295.2:1, was modeled after this statute with the error in it.
Right.
And so under current law, when you look at 18.2.10 and 19.2, 295.2 together, there's a cross-reference in there in 18.2.10. When you look at the two statutes together, post-release incarceration and post-release supervision are both required. That's current law. And so that's simply applying that current law to what we see as simply an error in the term to the statute in the bill as introduced, 19.2, 295.2:1.
Mr. Chair.
Senator Peterson.
So what you're saying, ma'am, is that there was an original mistake that was made as to 19.2-295.2 of using the word post-release supervision where you meant incarceration.
Yes.
And the incompetency level of this General Assembly was so acute that
I
we
would
actually
not
cut
say
and
that.
pasted it. Well, I'm saying it. And I was probably here. We cut and pasted it and simply rewrote the section
Yes.
using all the same wrong verbiage.
Yes.
And at all times where we use the word supervision, what we actually meant to use was the word incarceration.
Yes, because the sentence in the introduced bill on lines 28 or 27 through 29 is nonsensical as written. And so from our perspective, all we believe we're doing is correcting an incorrect term. That's honestly, that's what we think we're doing with this bill. Either the House substitute or the introduced version.
Mr. Chairman,
Senator Hovenchain.
I think we either like this or don't like it. I move to report.
It's nonsensical. I'm having trouble with saying incarceration is post-release. It's illogical. If you're either incarcerated or you're not.
Mr. Chairman, might I just step in? And I agree with you. And I do a little bit of criminal law in my practice, but I will tell you that I think that problem might not be solved in this bill. And I think this bill is really seeking to conform some things that were, made in error several years ago. And that might be an issue for us to look at going forward as to the terms and verbiage that we're using.
Why do we continue the error, though?
We're trying not to continue the error by passing this bill, I think is what I'm trying to say.
Yeah, Senator Morrissey.
I agree with you. And I thought Senator Peterson articulated it very well. Our error, the General Assembly's error, was the genesis of this problem. We need to correct that, and the patron has suggested maybe another bill another day. But here is what Senator Peterson and maybe some others are concerned about. Are we compounding the problem by using our previous error in this legislation? That's what I think some of the members are concerned about.
I think post-release incarceration already exists now under current law. Should the General Assembly revisit that policy, I think that's one issue. I think all our bill is trying to do, or on Delegate Jones' bill, is to try and correct an error in the statute. That's all we're trying to do, because when you have new judges, if they write an order and follow exactly the statute, their order is going to get rejected because it's using the wrong term. And so that's all we're trying to do. If there were a decision to change the policy, that is very different from what I think this bill is trying to do.
Mr. Chair, you have a motion and a second to report the bill.
Before we do that, what's the difference between Senate Bill 312, Senator Stanley's bill?
I think we've already conformed to that.
It was my understanding that our bill is conformed to Senator Stanley's bill, and that's why I was not here, admittedly.
Yeah, so, Mr. Chair, I would suggest, we've already passed the bill just on the same issue that we've just conformed this bill to our bill. This bill has generated a whole lot of discussion on this committee that we didn't have when the Senate bill. If we start killing the House bills, when we're sending over sending over something identical, we're inviting them to do the same thing to us.
Well, anyway, is the motion, have we moved to substitute, I think we did, the Senate Bill 312, put it into House Bill 752, right? Is a motion, we've already moved.
It's been moved and
Okay, that's been agreed to. All right, it's been a motion then to report the substitute to House Bill 752. Been moved and seconded. All in favor of the motion, vote aye. All opposed, no.
We can talk.
That's 13 noes too.
Mr. Chairman?
Continue talking. Yes, Senator Obenshain.
Having voted on the prevailing side by which we perhaps too expeditiously moved along House Bill 136, I move that we reconsider that vote.
We want you though.
All right, House Bill 136, a motion's been made to reconsider that bill. All in favor?
Hold on a second. I know you voted against the Senate bill. Are you sure you voted on the prevailing
I'm
side?
sorry.
Well, okay. I was going to say I'd make the motion to reconsider.
The motion been made to reconsider the substitute to House Bill 136. All in favor of the motion, vote aye. All opposed, vote no.
Mr. Chairman.
15 no 0.
15-0. The bill is now reconsidered. Delegate Collins.
Mr. Chairman.
Yes, Senator Obenshain.
My understanding is that what we did was we conformed this to Senator Marsden's bill.
Correct.
The House version really contained Senator Marsden's version plus another bill essentially was rolled into it. Eileen made the long walk back to the back of the room. She can walk back up and be Delegate Collins's wing person. And I think that maybe we moved too quickly and should not have conformed.
Okay. Yeah, go ahead.
Eileen Longenecker with OES at the Supreme Court. What happened in the House is House Bill 138, which was the bill recommended by Judicial Council and the CDC, was rolled into House Bill 136. So House Bill 136 is really two bills. The Senate only had the second paragraph, or the bottom language. That was the only version, the CDC Judicial Council recommended bill. So we understand the issue that's being trying to be addressed at the top of paragraph B. It's an issue for the courts as well. And so we would have no position on that language, but the language at the bottom is the language recommended by CDC and Judicial Council.
Mr. Chairman, I would move
Senator
to
Obenshain.
report without conforming.
Well, we need to reconsider the substitute.
Reconsider the vote by which we adopted the substitute. The motion's been made and seconded. All in favor of the motion to reconsider that vote, vote aye. All opposed, no. All right, motion.
15 no 0.
Okay, the bill in its original virgin form is before us.
Move to report.
It's been moved and seconded. Is there a second? Second. To report House Bill 136 by itself. All in favor of the motion, vote aye. All opposed, no.
Ayes 15 no 0.
Ayes 15, no 0.
Mr. Chair, now you're on.
Bill is reported.
Now you're on block 4.
Okay, thank you. Now we're on block 4, regular agenda. Okay, now we start getting into more fun. All right, Delegate Adams. Delegate Adams?
He's coming.
Is he coming? I'm just doing it in order. Delegate Les Adams. I'm sorry, no, Myers.
Myers.
Myers. Adam? Okay, Adams is first on the agenda. That's right, okay. All right, Delegate Adams.
Thank you, Mr. Chairman. I believe this is House Bill 1022.
1022 is on the last
this-
page. Definition of criminal justice agency.
Yes, sir, Mr. Chairman, members of the committee. This is a bill brought at the request of the Virginia Criminal Sentencing Commission, asking that the code section that identifies criminal justice agencies also identify this commission as a criminal justice agency along with the others that are listed under 9.1-101, and that would include Department of Criminal Justice Services, the Virginia State Crime Commission, and it's my understanding that this is reflective of how the commission is already treated in most cases, but they did run into a snag, I think, with some data compilation from the FBI that wanted to see that they were considered a criminal justice agency. The executive director of the commission is here to answer any additional questions,
Okay.
should the members have them.
Okay, Executive Director? Yeah, Senator Short?
If there's no opposition, I'd move to report the
Well,
bill.
you can explain it first, if you don't mind. Yeah, go ahead, explain it, yeah. Purpose?
Thank you, Mr. Chairman and members of the committee. I am Meredith Farrar Owens, the Director of the Virginia Criminal Sentencing Commission. Delegate Adams spoke to the bill very, very well. We do a number of research projects and studies and data analysis on a variety of topics, including recidivism and offender risk assessment. We use a wide variety of data to conduct those studies. We have sufficient access to state criminal justice data within Virginia. Our issues have arisen when we've tried to get data from the FBI, and we're encountering some challenges, and it's been suggested to me that to have us officially designated as a state criminal justice agency could smooth that process along a little bit as we try to access FBI data.
Okay, thank you. Any other questions? All right, is there a motion?
So moved.
It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no.
Ayes 15, no 0.
15-0. We were very eloquent, Delegate.
Thank you, Senator.
Appreciate it.
Mr. Chairman.
Okay, and your, the Executive Director is even more eloquent. All right, next bill is, let's see, Collins, Delegate Collins. Got it, Senate Bill 130, House Bill 137.
Yes, sir. Thank you, Mr. Chairman. Ladies and gentlemen of the Senate, HB 137 deals with guardian ad litems dealing with child custody cases. Basically, what's requiring is a written summation that they actually met with the child face-to-face, that they had done the hours, certify that the hours that they put into the case. And this complies with the other provisions of the code that we've put in to say the standards of care and the practice manners of our guardian ad litems dealing with juvenile cases. So this came out of the Family Law Coalition, and I would ask that, I think it's been vetted the last couple of years, been gone through a couple commission meetings and things of that nature. So if you have any questions, I'm happy to answer them.
Okay, any questions of the patron? Okay, would you like to step up and you're supportive of the bill?
Thank you, Mr. Chairman, members of the committee. Valerie LaRue from the Virginia Poverty Law Center. We strongly support this bill. We hear from children who are in foster care that their guardians ad litem rarely meet with them, and so this would encourage them to spend more time meeting with the child whose best interests they are representing to the court. Thank you.
Thanks. Any questions? Is any opposition?
Mr. Chairman.
Yeah, Senator McDougal?
So my understanding is guardian ad litem must be an attorney.
Yes.
Chairman.
Senator McDougal.
I understand what the goal is, but I guess a little bit concerns me that now we're going to be going down the road of saying that an attorney has to certify that they've done the job that the court has appointed them to do. If this is an issue, why are courts just not removing these people from being guardians ad litem, period? And are we now going to start saying on every case, did you go through and attest that you did what you're supposed to do?
Mr. Chair.
Yes, Senator Peterson.
Let me respond to Senator McDougal. I've been in private practice for 26 years. I don't think I've ever charged a client without sending them an invoice certifying that I did the time with the work I did. So why shouldn't our courts expect the same level?
Mr. Chairman.
Senator McDougal.
Mr. Chairman, this I don't think is this certification on the invoice, because there's an invoice that the individual has to fill out with the Supreme Court, and they have to sign under oath that they did those hours in court, out of court, and what it was for. But I don't think that's what this is.
Where do you certify it? in the bill?
So Mr. Chairman, to answer the question, there is a timesheet, obviously, that is placed with the court. What this is in saying is that what the court is, all the report's asking to do is that it says, I spent a half hour with speaking to the juvenile at his middle school or her middle school, or I spent a half hour in the child's home. So it's certifying the time that they spent face-to-face with the child to ensure that the court recognizes that they didn't do a 10-minute flyby to see what's going on with the child, so that there's an actual certification. So it's not so much of saying the court's going to have a litmus test, and that's not what the code calls for in other parts of the code. It's a matter of that we have guardian ad litems who are doing things by phone and not meeting with the children face to face. And we think that if you're representing a client in court, that you should at least have some personal contact. So I think to the senator's question, and the issue is that it's not so much certifying how many hours they spend on the case because they're already doing it on a time sheet. I think it's just certifying the amount of time they actually spend with the child on and any other interviews that they do.
Okay. Senator Stewart, did you have a question?
Mr. Chairman, Delegate Collins, I share the same concerns with Senator McDougall. I mean, the attorney is either competent to be a guardian ad litem or they're not. They've taken a course to be trained. They have to satisfy requirements. If the court is concerned that the person has not done their job, why can't the judge question them, voir dire them like they do when somebody gives a guilty plea?
Mr. Chairman,
I don't understand why we're going to go down the path of now, and this is the beginning. Now we're going to start having attorneys certify in certain areas of the practice that we have done things according to a checklist. Get rid of the guardian if the guardian's not doing their job.
Well, Senator Stewart, Mr. Chairman, Senator Stewart, the response I would give is in a lot of jurisdictions, you only have maybe a handful, maybe 2 or 3 people who are willing to be juvenile guardian ad litems. I have a case right now where there's only one guardian ad litem that is taking court appointments right now through the court, and that guardian ad litem has yet to go to the house where the child is residing. The case has been going on for 4 months, and I've written letters to the judge, and the judge says, well, I've advised him as well. And I think that if I agree with you, I think that if we have guardian ad litems who are not meeting the standard of care that we have put in.
Mr.
Yes,
Chairman,
Senator Stewart.
What would this change? If you've written him a letter saying he needs to go visit the child at the house, the judge has done the same thing, what does this bill do?
And so, Mr. Chairman, Senator Stewart, what I would say is that what we are doing is now we're putting an onus on those guardian ad litems. This is all part of a overall attempting to try to make the transparency of the guardian ad litems of what they do and what they don't do.
Okay. Any further questions? All right.
Mr. Chairman?
Yeah, Senator
I guess my
McDougall.
question is, what penalty would an attorney or that's acting as guardian ad litem face if we pass this versus what penalty would they face today if they didn't go see the child before they appeared in court on the case?
Mr. Chairman, Senator, how I would answer is obviously there's no penalty, but obviously it goes to if the guardian ad litem is making an oral representation to the court of their determination of where the child should stay or what the visitation schedule should be, and the judge goes, well, I see that you do not spend any time with the child. How are you coming with this determination? I agree with the senators to say, well, why is that guardian ad litem being appointed to represent juveniles if they're not doing their job? But we also put in code where it's required to have a guardian ad litem in certain cases, particularly DSS cases. And I think that it's important for the court to know before any recommendation is evaluated how much time that they spent with that child, because what we've found over the last several years through our studies is that the guardian ad litem, there's several guardian ad litems that are not spending any time with the child whatsoever.
Is there anybody from the Supreme
Mr.
Court would
Chairman.
like to say something? Yeah, coming up. Yeah, Senator Stewart.
Mr. Chairman, I was just going to say that, and I'm not trying to be difficult with the patron, typically being really good bills. What concerns me here is we're almost giving a per se blanket exception to this guardian ad litem if they sign a certificate, which to me is meaningless. The judge has every opportunity to question that attorney to determine whether or not they've done their job, whether or not they're competent to be a guardian ad litem, and we're replacing that with signing a certificate. And I just think that's a bad idea.
Go ahead.
Mr. Chairman, members of the committee, Sandra Carrison, Office of the Executive Secretary, Supreme Court of Virginia. I've been involved with these issues and had many conversations with Delegate Collins and the proponents of the bill. The court has no position on the bill. Just to speak to some of the questions that have been raised about guardian ad litem practice, I have a role just in the administrative procedures because my office receives the continuing education certificates and, in fact, the initial qualification certificates, and we assist with putting on the program for the initial qualification. And so since the bar initially, the family law section of the bar raised the initial concerns in 2015, a work group was formed in 2016 to address the concerns. As a result, just to give you an idea of some of the steps that have been taken, the orientation program for GALs was improved. A rework, the Chief Justice sent out a mentoring guidelines for guardians ad litem were developed, and the Chief Justice sent those out to guardians ad litem. Juvenile and domestic relations district court judges were trained on holding guardians ad litem accountable. And, you know, in my experience, because I get calls about this, I'm hearing from judges about holding guardians ad litem accountable. And that's the main point that I want to make in response to these questions, is that I hear from judges about what they're doing to hold guardians ad litem accountable. And that's really what I can respond to because I hear from them. We are getting ready in our pre-bench program to train new judges to do this very same training program that we rolled out to JDR judges, to our brand new judges that are elected.
Would it be helpful to have a certification program?
Based on Delegate Collins' bill that was in 2018, that was the bill that required, it provided that, specified that judges could cut the pay. The General Assembly approved that judges could cut the pay of a guardian ad litem that was paid through the state. This is different for circuit court judges that are paid privately by parties, and I can assure you that a circuit court judge would have the same authority to cut the pay. If a guardian ad litem charged too much, that would be a plenary authority, I would be sure. But if the guardian ad litem is paid by the state, the General Assembly approved that the JDR judge could cut the pay. And now we have a disclosure form that the guardian ad litem, this is voluntary, but the judges do use this in their courts, and they say, in order to make sure that I know what you've done in the case, you know, in some districts, this form is already used and it has the performance standards listed. So these tools are being used.
So you're saying this type of form is being used elsewhere?
Yes, sir, voluntarily, in order to implement that bill that was House Bill 278,
Okay.
I believe, in 2018.
Senator McDougal?
Mr. Chairman, I hear today and have heard from others that there's an issue. My concern is this is not going to address the issue. Mr. Chairman, I think what could address the issue and actually make it change is if the court was asserting in the order that they had voir dired the guardian ad litem, and the guardian ad litem had performed so much time of face-to-face visitation with the child. And so, Mr. Chairman, I think what this is going to do is just create another piece of paper, and good guardian ad litems are that get paid very little are going to be continually frustrated at paper. We really want to get at the issue. Let's make the judge certify that they've asked whether the guardian ad litem is visited with the child and how much time when they fill out that order.
Yeah, Senator Morrissey.
I've listened to all the parties, and here's where, if there is a disconnect, here's where it is. We all agree that there's no issue that there should be a face-to-face between the GAL and the child. We all agree that. The issue that my colleagues, Senator Stewart and Senator McDougal, have is, should there be a certification that they did that as set forth in 52 and 54? I'll wait until she's finished.
No, I'm sorry. I think
Let me finish.
Go ahead, yeah, please.
So, what they're also concerned about is perhaps going down that line that the next time you appoint an attorney to represent an indigent defendant, that the attorney certify, oh, by the way, I met with him in the jail for 2 hours. Here's why I'm going to support the bill. I understand this is different, but when you sign that certification, I spent an hour with the child, you're going to make sure that that guardian ad litem actually does that. We're now going to have more GALs visiting the children because of this certification. It's for that, although my colleagues have a good point, we're going down a slippery slope here because we're going to make other attorneys do it. But I like the idea that this is an avenue that will force a GAL to see a child because they're not going to put on that form certified that they met with a child when they hadn't. For that reason, Mr. Chairman, I think we fleshed it out enough. I would make a motion to report.
Okay, it's been moved and seconded to report. Any further discussion? Anybody against the bill? Okay, all right. All in favor of the motion to report, vote aye. All opposed, vote no. Okay.
Ayes 14, noes none, and 1 abstention.
14, 0, and 1. Congratulations.
Thank you, Mr. Chairman.
Okay,
Thank you, members of the committee.
Thank you very much. Delegate Jenkins, in order of sign up here. Okay. Is Delegate, okay, here he is. Delegate Jenkins. Welcome.
Thank you, Mr. Chairman. House Bill 821 is an agency bill, and it's simply to help the Department of Fluorescent Science properly manage DNA samples after a proceeding in the courts.
Okay.
There is a representative here to speak to the bill if
Okay, good.
the
Thank you.
Senate has
Yeah,
questions.
welcome. Okay, go ahead. Step right up. Welcome. Your name?
Yes, thank you, Mr. Chairman. My name is Linda Jackson. I'm the Director of the Department of Forensic Science, and as Delegate Jenkins said, this is an agency bill. It is really a cleanup bill to remove just the word felony in one part of the code in dealing with DNA databank samples. It would occur when someone has their sample taken upon arrest. If they are then found not guilty, the code section says that we will remove those samples from the DNA databank unless they have some other eligible reason for being in the databank, which would have initially been just felony convictions, and since the General Assembly has added misdemeanor convictions, it just removes the word felony so that they're all included.
Mr. Chairman.
Okay, Senator Sherrill.
So I remember, I think 2 years ago, we added a whole bunch of misdemeanors to the DNA requirement. And I can't remember off the top of my head what some of them were. But I think what you're saying this does is that, say somebody in 1990 got convicted of some offense for which we take DNA now, but we didn't then. If they later get charged with a felony and the felony's dropped, their DNA still gets put in the databank, even though at the time they got convicted it wasn't put in?
Go ahead.
And they're not guilty of the felony?
So Senator Serval, this is for samples that we already have in the databank. because there could be a time where someone has had an arrest and had their sample taken, and we have put it in the data bank. They are then convicted of a misdemeanor that is, well, the timing of which can be that that a person could have more than one conviction, and the code section that talks about taking a sample implies that if there's already been a sample taken, then there's no reason to take another sample. And so it's not that it would make you take a sample from 1990, it's that if we already had it in the data bank, that we wouldn't have to remove it.
Wouldn't have to remove it, or wouldn't have to do it again?
It wouldn't need to be done again, and we wouldn't have to remove it, because we would not have to remove it if there was some other qualifying offense reason for it to be in the data bank.
Okay.
Mr. Chairman.
Any question, Senator Sherrill?
I'm still confused. I mean, I've been reading the words of the bill, okay? And I know all we're deleting is one word, but the way I read it, if you're charged with a felony, anytime you're charged with a felony and your blood is, I guess, taken, if it's dismissed, the blood's destroyed before it goes in your data bank, right?
So say that one more time. I don't believe that was correct.
Mr. Chair,
Charles?
under the statute, if you're arrested for a violent felony, and they list what the violent felonies are in this 19.2, 310.2:1 section, they'll take a DNA sample for you when you're arrested. They'll swab your cheek, they'll stick it in the data bank. The current law requires that the sample be purged if you're later acquitted or the charge is dismissed.
Right.
Unless your sample is already in the data bank. So what this change is doing is, because the General Assembly added a bunch of misdemeanor convictions a couple of years ago, is basically just deleting felonies. So if they have your sample on one of those misdemeanor convictions, which is in section 19.2, 310.2, which are assault and battery, sexual battery, some of those carnal knowledges and custodial relationship offenses, then trespass, then they can hold on to that sample taken from that violent felony arrest, because they already have a sample in the data bank.
Mr. Chairman, I have a question for council.
Senator-
I'm still not following this.
Senator Sherrill.
You get arrested for some violent felony. Upon arrest, swab's taken, it's put in an envelope. The envelope lives at the courthouse, and then your case is dismissed, the envelope's destroyed.
No,
No.
that's where when they take that, so your client gets arrested, they're down to jail, they take the Q-tip swab, put it in a package, they send it to DFS immediately. It doesn't stick around at the courthouse. They get it, they run it against the database while your client is pending trial, and then what results from there determines what they do next. Do they keep that in the system or not?
Okay.
So Mr. Chairman, before we had misdemeanors that you could collect your DNA for, this language was right. But when we added all those misdemeanors, they're trying to clean it up. Now, I'm not a fan of the misdemeanors being DNA swabs,
Me
but
neither.
if you like the current things for which you can take a DNA swab, then this doesn't do any harm.
That's correct, Mr. Chair.
But if you don't like misdemeanors, then you might not like the bill.
Senator McClellan.
Well, whether you like adding misdemeanors or not, the fact is that in both instances, they're taking the DNA sample and they don't need it anymore unless there is a pending charge for which the sample was necessary.
Correct.
And because the sample is necessary for both misdemeanors and felonies, you're not changing substantive law here. You're just changing the words of the law to match the substance we passed 2 years ago.
Yes, ma'am.
Okay, is there any further discussion? Is there a motion? Been moved. Is there a second to report? Second? It's been moved and seconded that House Bill 821 be reported. Any further discussion? All in favor of the motion, vote aye. All opposed, no. Okay?
15-0.
15-0. Thank you for coming. Appreciate it. Congratulations. Okay, next bill, let's see. Senator Delegate Bourne. I'm just going down the list here.
Thank you, Mr. Chairman. Hopefully, I'll be brief and won't trespass on your time very much. House Bill 1346 is a recommendation from the Boyd Graves Conference. The legislation simply brings our code into consistency with Rule 3:25, the Rules of Supreme Court regarding attorney's fees. The bill simply just makes it clear that a claim for attorney's fees must be included in the complaint, cross-claim, or counterclaim. It removes a provision in the code stating that a party can otherwise notify the other party in a separate writing that an application for an attorney's fees will be made to the court. Again, simply put, it's just bringing our code into consistency with the rules of the Supreme Court, and I'd be happy to answer any questions.
So all he's doing is saying in the pleading, it's got to say.
Correct.
Requesting, okay. Any questions?
I move the report.
It's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, no. Motion carries. Go ahead.
I thank the committee for your time.
15-0. Congratulations. Thank you very much. Okay, the next bill is Delegate Reed. Delegate Reed.
Yes, Mr. Chairman, members of the committee, House Bill 721 is before you, and I know I heard you earlier talking about having to make code correction from maybe 10 years ago. This is making code corrections from the last year. So fortunately, in this instance, we've caught it sooner rather than later. This is for post-adoption contract and communication agreements. We passed this legislation last year. After it became law and started to looking at implementation, we realized that in the process of developing the law last year, we ended up with too many cooks in the kitchen. So we ended up with too many semicolons and too many ors, and that resulted in there not being sufficient clarity when the actual law was being implemented. So what you have in front of you now is a piece of legislation that will clarify what the intent was and to make sure that we're doing what we intend to do, which is to create a permissive opportunity for post-adoption communication, contact and communication agreements to be put in place between children and their birth parents. And again, it's permissive in nature.
Okay. Is there?
Okay, I got it.
Just got a question of the patrons.
Okay, so Delegate, I take it that the sub-Romanets are superior to the lowercase letters. In other words, you have the 1, 2, and 3, and then the A, B, and C essentially delineate the sub-Romanets.
Just a second.
Oh, you don't have the bill?
That was a question that I raised earlier with someone.
Do you want to look at my copy?
Mr. Chairman, Senator Peterson, that's correct. So A, B, and C go with Romanet 1, and then 2 and 3 stand on their own.
Okay, further question?
Yes.
Are we consistent in the code that we use sub-Romanets to divide up a subsection before we go to A, B, and C?
Well,
Yes, Mr. Chairman.
Code Commission
Okay,
has
all right,
a
just checking.
policy on that.
All right.
Mr. Chairman.
Mr.
Chairman.
Consistency.
Yeah,
I'm all about
Senator-
consistency.
Senator McDougal.
I'm getting all these sub-Romanets and ABCs, but are we also adding in an involuntary termination piece? Or is that, because I'm not seeing how that was in there before, am I just looking at it wrong?
Senator McDougal, Mr. Chairman, Valerie LaRue from the Virginia Poverty Law Center. That was one of the things that needed to be clarified from before, because yes, it's clear from the context from the original language. So if you look down at line 21, or 20 and 21, where it says, unless the parental rights of the birth parent or parents have been terminated pursuant to subsection E of 16.1283, a local board of social services or child welfare agency required to file a petition pursuant may inform the birth parent or parents and shall inform the adoptive parent or parents that they may enter into such an agreement. Subsection E is when a parent's rights are being terminated because of aggravated circumstances. So absent aggravated circumstances, it was intended to apply to parents whose rights were terminated. Because of the language, the way it ended up, and the reason why it ended up that way, I'll take responsibility for, because it got changed several times and going back and forth between different interests, the Supreme Court and other stakeholders, I think that got lost. And so this is the intent to have that in there. The science shows that even children whose parents are terminated for abuse and neglect benefit from having contact with their birth parents for several reasons, which I'm happy to go into. But it's been unclear whether the statute applied to those parents. Judges will always have to go by the best interest of the child in deciding whether to approve such a contract. The foster parent does not have to enter into it. As Delegate Reed said, it's permissive. The foster parent can say, no, I don't want to enter into this. And the child can also say no, that they don't want to enter into it if they're age 14 or older.
Okay. Any further questions? Yeah, Senator Chafin.
Yes. A question for the patron. So this is in a situation where other children, one or more other children, have previously been involuntarily terminated their rights, correct? Am I right about
Where
that?
Mr. Chairman and Senator, it's where the parental rights have been terminated.
Yes, Mr. Chairman, another question.
Yeah, Senator Chafin.
And so what we're getting at here is, in that event, your language would allow the child to have a voice as to whether or not they want to have a post-adoption contact. Am I right about that?
That's correct, Senator.
And that's really the thrust of this bill, isn't it?
It is, but again, it is permissive in nature, and it still relies on the court to make the final determination and what's the best interest for the child.
Mr. Chairman, but nonetheless, the court would be required to bring the child in and ask the child, do you want to have contact with your parents? Post-adoptive contact with your parents. Am I right about that?
Senator Chafin, the law already says that in permanency hearings, which this would be a permanency hearing, that the court is supposed to consult with the child about their wishes in permanency hearings, regardless of age. Children who are age 14 and above have a right to, for instance, veto the termination of their parents' rights. So already at permanency hearings, the child is supposed to be consulted. In this case, the child doesn't have to be in court to be consulted. That would be the responsibility of the Department of Social Services that is handling that case.
Okay. Any further questions? It's been moved and seconded to report the bill, House Bill 721. All in favor of the motion, vote aye. All opposed, no.
Mr. Chairman, Senators, thank you for your time.
Congratulations. The bill is reported 14, 0, and 1.
Thank you.
Okay, thank you very much. Next person that list here is Delegate Krishik. Okay.
Thank you, Mr. Chairman, members of the committee. HB 172 would create the Virginia State Police Electronic Summons System Fund, would allow the Virginia State Police to issue a fee not to exceed $5 as part of a cost in each criminal or traffic case to be used for the implementation and maintenance of the e-summons system. A couple years ago, I was able to get funding in the budget for a 2-year pilot program for the e-summons up in Northern Virginia. And in October, there was a report issued and had lots of immediate positive feedback. And it recognized that it improved accuracy with error rates at less than 0.1%. And the efficiency was greatly improved, decreasing the average amount of time that the troopers spend on the side of the highway, which obviously also saves their lives and the lives of the people they pulled over. In fact, there was a 61% reduction from 26 minutes to 10 minutes. So that's about 22,000 additional work hours per year just in the pilot division that was saved. And of course, it saves us on rubbernecking from people watching and all the traffic that. So I think it's a great bill. It saves lives, saves money, and I hope you will support it.
Mr. Chair.
Yeah, Senator Peterson.
Yeah, I had this bill 10 years ago and Cuccinelli killed it. Maybe it's 12 years ago.
Darn.
I'm amazed we haven't done this yet because we've been talking about this for, Keenan, what, at least 12 years?
Yeah.
10 or 12 years?
Sheriff Huggins here and Captain Hook. Okay. We can, we've been working on this for a while.
Okay.
Mr. Chair.
Yeah, Senator
Dees. Can I ask staff a question? I mean, we had a fee for the state police on the Senate bill. How does this relate to that?
Yeah.
What?
Haven't we already done
That's
one fee?
that's on registration.
It's different.
Mr. Chairman, I think we did do another courthouse security fee
Okay.
that doesn't go to the state police, that's not related to this. But I think that, I agree with Senator Peterson, this ought to be done. This would be great. The problem that I have is it is yet another fee on a criminal charge. And I think that it's okay to have some, but for the most part, more people are getting assessed more in fees than they are in the actual fine. And when you look at it totally, that number's gotten fairly high for a number of people. So I certainly understand the need, the safety, all those things. The concern I have about it is the additional step on fees for individuals.
Yeah, all the funds will be going to funding software, hardware, and associated equipment costs, right?
That's correct,
Okay.
Mr. Chairman. I
All
would
right,
also
Mr.
mention, if I could respond, Senator, is that like Fairfax County Police already have the e-summons, they already have the $5 fee. This would put the state police at the same level as the rest of all the, the local jurisdictions that are charging this fee and that do have e-summons. So right now, they're still using the old paper and pen system. And so you also get mistakes. You get handwritten mistakes. There's a lot of, it's an old carbon thing.
Make it more efficient. More for you, Senator Deeds.
An issue that was raised was how many localities have to pay this fee? It's not a statewide fee, is it?
It's a court cost fee.
I mean, with the fee you were talking about, it's a Fairfax County fee or is it a fee?
It's a lot of jurisdictions. Here,
court
let me
cost.
let the cat.
Is it court costs? Yeah, go ahead.
Mr. Chairman, Senator Deeds, Keenan Hook with the State Police. The fee is authorized statewide to local agencies. It is not authorized for the state police to assess that fee outside of the pilot program that was done in Northern Virginia that Delegate Krizik referenced. So this bill just seeks to bring us in to what the local agencies can already do, assessing the same $5 fee. In this case, it would be assessed for summonses issued by state police, whereas now it's only assessed on summonses issued by the localities.
Mr. Chair, the point is, while it might be authorized statewide, right now it's only paid in Northern Virginia.
No, Mr. Chairman, Senator Deeds,
Mr. Chairman. Go ahead, Mr. Chair. Let the state police explain it. Go ahead.
Mr. Chairman, 2 years ago, when this came up and it resulted in the pilot, the Delegate Creasy, there was about 22 jurisdictions that were using the e-summons program at that time. I'm not aware of who has been added since then, but you might remember that as part of that initiative 2 years ago, we found out that there were jurisdictions, most notably Fairfax County, that were applying the $5 fee on the tickets we were writing by hand. We're not authorized to use the e-summons program. Even though we developed this program years ago, we're the only ones not authorized to use it. And so the appropriations language 2 years ago not only set up the pilot, but prohibits the locals from assessing the $5 fee on tickets issued by the state police.
Wayne.
They stopped that. Yes, sir.
Yes, Senator Peterson.
Is this outside of the money that we have dedicated for you under the registration fees? Is
Correct.
This separate?
This is separate.
Yeah, very different, yeah.
Yes.
Okay, Senator Stewart.
Thank you, Mr. Chairman. Mr. Chairman, as I recall, this e-summons fee was something that I did not support in the very beginning, but it was just supposed to be collected to set up the e-summons systems in these counties. And then there was some question about what happens to that fee after the systems were set up and paid for. And this is kind of what I was concerned about. And there's nobody here who has more respect or support for the state police from me, but you look at all of the assessments on somebody who gets a speeding ticket, and we're constantly adding more assessments to them. It becomes unconscionable at some point in time. I mean, we've got a courthouse fee, a library fund fee, and the list goes on and on and on. And that's in addition to their court costs and any potential fine that they may get. And what frustrates me is I don't know why we don't fund the state police in the general fund. They are providing a necessary, a critical public service. Why aren't we funding them in the general fund? Why do they have to come to us with bills like this to request little fees on things to get the money that they need to protect us?
Senator Morrissey.
You know, I'm going to associate my comments with the statements made by the senator from Prince George. Here's the other problem. I fully agree, Mr. Huggins, that the Virginia State Police and Delegate electronic summons systems is important. It needs to be funded. Here's how we're funding it. We're funding it by assessing a fee to an individual who was charged by the state police officer. If there's nobody else in the room that sees the problem there, let me try to drill it down. There is a direct nexus between the person issuing the summons, the state police officer, and there being a fee assessed to that paper document. Many, many years ago, we said, 40 years ago, we're not going to pay a magistrate per search warrant that he issues. It should be funded, but I have a problem, and I want somebody to tell me that I'm wrong, that we're funding this, or the fee is being assessed only if the issuer of the summons charges that person with a particular offense.
Mr. Chairman, I absolutely agree that there ought not to be a nexus between a law enforcement officer's enforcement decisions and their budget. All we're asking for is the same authority the General Assembly has given every other law enforcement agency in Virginia except us. We're the only ones. So the problem you're painting, Senator Marcy, already exists statewide, not only as it relates to the e-summons. And I'm going to open a can of worms here, admittedly so. Jurisdictions, local jurisdictions throughout the Commonwealth adopt state code by reference and then charge traffic offenses under local ordinance. Why do they do that? Because the fines collected pursuant to our enforcement actions, our meaning the state police, are required by the Constitution to go into the state literary fund. There is no such requirement for those funds collected pursuant to violations written under local ordinance.
Mr. Chairman, he's absolutely correct. That's why local cities, some counties, have an ordinance that mirrors a state code violation because they know the money goes there. Here's my problem. How about this? Every time a Commonwealth's attorney has a successful conviction, a $5 fee, cha-ching, goes to the Commonwealth Attorneys Association.
Mr. Chairman.
Do you, Scott, I'm almost done.
Okay. I'll go down the rabbit hole.
Here's the problem. There is a nexus that's tying a law enforcement officer to the money that's ultimately raised. And Wayne, you're right. I get what you're saying. It's been done by local authorities, and why don't we do it? I think the problem is that it's being done at all. I think it ought to be funded through another mechanism.
Mr. Chairman.
Senator Scott Shervill.
Thank you. First of all, and speaking to the bill, I guess, and then I have a motion. But first of all, I think Senator Peterson got interested in this because I brought it to his attention years ago for some reason I can't remember now. And then I eventually got Delegate Bill to waive it to carry for me when I was in the other body who eventually passed it. And my recollection is, this is aside, I think the whole reason this came about this way was because at the time we were trying to push it through, the state budget was in a ditch and there was no money to pay for anything. And it was brought to our attention, this is a good policy, A, because it makes the traffic encounter a whole lot more efficient on the side of the road. So it makes, all you do is scan a license, you're in, you're out, hand in the thing, you don't have to spend a lot of time scribbling it. And every time an officer is on the side of the road walking around, they're a target for a car going by to get hit and killed and injured. And so we did it as a public safety measure. It also would allow officers to actually write more tickets and get more fine revenue, and was another justification that I remember. In any event, The only way this software was going to get funded was by setting up this system to fund it, because none of the localities wanted to front the cash and pay for the system, and they didn't fully believe in it. Anyway, we crossed that Rubicon a long time ago. The state police clearly needs the authority, like everybody else. We got to give it to them, and this only pays for the actual software and the system and the stuff. It'll generate probably more fine revenue for us. It'll probably keep officers more safe. And if there's an issue with the broader policy, that's probably a different bill. So I think I moved to report the bill. I think we need to
This
move
will
it on.
make it more efficient, I understand, right?
Yeah.
Yeah.
Much more so. And just to give you a real-life example, when I was a trooper, I issued on average 1,000 summonses per year. Each summons took me about 15 minutes encounter with the public. That means I sat on the shoulder of Interstate 95, 66, and 395 for about 15,000 minutes, or 250 hours each year. The pilot showed that encounter is reduced by about 60%. So rather than sitting for 250 hours, I would have only sat for 100 hours. And to put a fine point on this, and to get to the real reason we need this, J.A. Walker, Jessica Cheney, Mike Fox, Jose Cavazos, Jerry Hines, Ricky McCoy, Leo Witt, James Biggs, Robert Lohr, Robert Hill, Mike Blanton, Jacqueline Vernon, Harry Lee Henderson, and Jim Hughes have one thing in common. They're all state troopers killed in the line of duty on the shoulders of roads, and that's a partial list in the Commonwealth of Virginia. And that's the reason we need this bill, is to protect not only us, but the motoring public, because they are exposed to the hazards 60% less at the same time.
Okay, thank you very much. Senator Morrissey.
Wayne, Mr. Huggins, I love everything that you do. Are you saying we need this bill, or the alternative, we need the funding for the Virginia State Police electronic summons system, which I agree with 100%. Which are you saying?
We need there is no budget amendment. We need the authorization to begin this project statewide immediately.
So you're saying both, really, I think. Okay, is there a motion?
Mr. Chairman?
Yeah.
Is there a motion to report and refer to finance?
Not yet, go ahead.
Well, I'll make a motion to report and refer to finance.
All right,
I'm gonna vote to move this bill forward, but I'm hoping when we get it to finance, we can talk to some of the esteemed members and see if we can't figure this another way.
Okay, it's been
Yeah,
moved, and
Senator
there's a
Lucas,
second.
you're an esteemed member.
It's been moved and seconded to report the bill and re-refer to finance. All in favor of the motion, vote aye. All opposed, no.
That's 15-0.
15-0.
Mr. Chairman.
Congratulations.
Thank you.
Okay, thank you very much. Now we have Delegate Mullen. Delegate Mullen, you're next.
Wow.
Yep, up and at 'em.
Oh, you know what? I'm just having fun. Speaking of which, our esteemed chair is on fire on Twitter right now, so doing some good things about high-quality steaks. Is that right?
About what?
You were tweeting about 25 minutes ago, and I thought it was very funny.
I was?
Yeah.
I don't tweet. I don't tweet. I don't have Facebook. I don't do any of that stuff. Okay. House Bill 663, Delegate Mullen.
Thank you, Mr. Chair. Mr. Chair, so as well as some of our colleagues here on this committee, I actually serve on the VASAP board. And a few years ago, there was a requirement that we start to have ignition interlock on all DUIs. And the committee made, I think, a very intelligent decision to not put GPS on those ignition interlocks. Many of them come with GPS, but we don't turn it on because that's a real privacy violation. And what an unintended result of that is that it has been very difficult to prove venue when somebody is circumventing ignition interlock. In fact, here in the greater Richmond area, there is a young woman who has had a DUI and has been she works at a bar, and she has been routinely having people who work at the bar blow into the ignition interlock for her so that she can drive home, because the rolling stop does it at 8 minutes, 20 minutes, and I think 45.
Pretty clever.
I could be...
Pretty clever, huh?
You know what?
Anyway,
when I was in private defense, I would have been very impressed by something like that. The problem, though, is that you can't prove venue if you don't know where the person is. And so what this bill would say is that the venue for circumvention of the ignition interlock may lie in the place in which you were ordered to do ignition interlock. That's the bill. I'm happy to answer any questions if anyone has any. This is at the request of the VASAP board as well.
So if you were convicted and in Richmond, and later you violated the terms in Fairfax, you'd have to come to Richmond.
Well, if you are convicted in Richmond and you don't, and we don't know where you are, then you would have to come to Richmond. But if we do know where you are, then we're happy to prosecute in the place in which we
Okay,
know.
wherever, okay. Well, wouldn't you know?
So the problem is that it takes a picture of you when you're blowing incorrectly, circumventing, but it doesn't say where you are. And so because cars are, especially down Hampton Roads, you can be in the 7 cities within 20 minutes, and we wouldn't know which jurisdiction you happen to be in. And so that's why.
Where do you get, where's the picture? After when you're blowing, does it automatically?
Yes, so the ignition interlock, by our mandate, takes a photograph of you when you blow.
Okay. All right, any questions of the patron? Is there any discussion?
Mr. Chairman.
Hey, like somebody here would like to speak in favor of it?
Oh,
No,
yes.
Against it?
Okay.
Support?
Hopefully in favor.
Mr. Chairman, members of the committee, I'm Richard Foy from the Commission on VASAP. Just wanted to point out that we strongly support this bill, that over the last 18 months, we've identified approximately 400 circumvention cases. And as Delegate Mullen mentioned, since vehicles are mobile, it makes it hard for us to establish a jurisdiction in order to make a charge. We do take these people back lots of times if it's the will of the court for violation of their probation, but we need to understand that this is actually a separate Class 1 misdemeanor criminal offense when a person circumvents. And also, there's all those ignition interlock cases where it's actually an administrative interlock requirement. So that's not tied to any particular court. And it also makes no provisions for the third party who's assisting the person circumvent the system, which is also a Class 1 misdemeanor for that party. We've had a lot of cases. One of the most egregious ones recently was a 7-year-old that was blowing a breath sample for his intoxicated mother on school grounds. And so this is the type of thing that we're dealing with. And so establishing venue is critical for us in these cases, and we think it'll positively impact highway safety. So we would hope that you would report this bill.
So people actually do this a lot, huh? Okay, yeah, Senator Stewart, or Senator Chafin. Okay.
Mr. Chairman.
Yes, yeah, sure. Steve?
Currently, the bill requires that the venue be in the jurisdiction where the order was entered. And I suspect, and this is a friendly question, that the patron would want it to be either or. If you know where the offense occurred, if it occurred in Henrico, but the order was entered in Alexandria, wouldn't the patron, Mr. Chairman, want the offense to be prosecuted in Henrico?
Yes.
Okay.
If someone made such an amendment, I certainly would find that friendly.
On line 79, Mr. Chairman, after the word shall be, insert where the offense occurred or, and then it would read the jurisdiction where the order was entered.
Is there a
Mr.
second?
Chairman, just a question.
Is there a second first about the amendment?
A question on the amendment.
Senator Stewart.
And I'm just thinking out loud because you all move faster than I can think. Would you not need the order, the original order from the court that entered the order in order to prosecute on this? So don't you have to, you have to have we have to have the conviction in order to prosecute for this.
Mr. Chair, that's correct, but the court could send a certified copy of the order to the jurisdiction where the offense occurred. The concern that Steve raises and that I shared was, if you have somebody in Henrico who circumvents the interlock, is Henrico police actually going to contact Alexandria, and Alexandria going to want to have the resources to prosecute somebody who circumvents their interlock in another jurisdiction?
Okay, yeah. All right.
I
Any other
I would
questions?
consider that a friendly amendment. I think you're raising an excellent point, and I think that that can be handled in the way that was just explained.
Been moved and seconded to have this line amendment. Discussion, all in favor say aye. Aye, all opposed no. Motion carries with the line amendment. It's been moved and seconded to report the bill and the line amendment. All in favor of the motion say aye, or vote aye. All opposed vote no.
That's 15-0.
15-0. Thank you very much.
Thank you, Mr. Chair.
Appreciate
Good to see you all.
Thank you. Okay, the next person up would be Delegate Hurst.
Thank you, Mr. Chairman, members of the committee. Before you is House Bill 639, which is an agency bill from the Department of Behavioral Health and Developmental Services. The bill will allow for the option of remote hearings for individuals found not guilty by reason of insanity that are currently at a state psychiatric hospital. The House version as introduced included the initial evaluation as well as any appeals that may happen. The version that is in front of you has been amended to only be the recurring yearly evaluations that sometimes are routine but still require law enforcement and DBHDS staff to have to use a tremendous amount of manpower and resources in order to travel great distances to do these hearings. And so they are asking for that burden to be lifted and for them to be able to use teletestimony in order for these hearings to occur for NGRI individuals.
So it could be agreed to either by the individual or by the Commonwealth.
Yes, Mr. Chairman. So there is provisions in there unless objected to by the acquittee's attorney or the attorney for the Commonwealth, and then in those cases they would still appear in person.
Okay. Any questions of the patron? Any
Mr. Chairman.
in favor? Yes, Senator Morrissey.
Delegate Hurst, right now, a proceeding for somebody who's an NGBRI is held in the circuit court where that person was acquitted. The defendant who's incarcerated at Central State, his attorney, the local NGBRI representative, and anybody else all appear in court, right?
Mr. Chairman, Senator, yes?
Your bill hopes to do the following, limited to the defendant himself or herself who is at Central State. There's where the two-way electronic video would take place. It's just between that individual and the court. Is that correct?
Mr. Chairman, Senator, yes, correct.
All other parties would be in the circuit court watching this. Is that right?
Mr. Chairman, to the Senator, yes, that's correct.
All right. Okay. Is there any other questions? Anybody here to speak for the bill or against the bill? Okay, for the bill. Okay.
Thank you, Mr. Chairman, members of the committee. My name is Emily Lowry. I'm with the Department of Behavioral Health and Developmental Services. The administration supports this bill, and we are here to answer any technical questions you may have.
Okay. Any questions? It's been moved and seconded that the bill be reported. All in favor of reporting Bill 639, vote aye. All opposed, vote no.
Thank you, Mr. Chairman, members of the committee.
Okay, thank you, Delegate Hurst.
15-0.
15-0, the bill passes. Okay, the next person up is Delegate Rome.
All right. Thank you, Mr. Chairman, to the members of the committee here. This is a constituent service bill. This is HB 780. And so HB 780 provides for the acceptance of electronic and digital proofs of service within an existing 72-hour window to return proofs of service back to a clerk of a court. HB 780 would provide that a clerk's office would have to accept an electronic or digital proof of service in lieu of an original copy in form of a photocopy, facsimile, or other copy of the original proof of service, provided that the submitter provides a statement that such copy is a true copy of the original. And so one of the things I want to point out here is that first, we have a lot of existing precedent for this existing in other states, but here locally in Virginia, the problem that we have is that we have a mismatch. In some counties and areas, they are currently accepting copies. In other areas, such as Prince William and Fairfax, they are not accepting copies. And when I talked to our clerk of the court about it in Prince William, she said, I would be willing to do this, but we haven't been given clear discretion from the General Assembly about whether or not we can. And so my constituent who actually does this for a living, he was presenting the problem with this in that in some areas, including a couple counties in Southwest, he's presented this and it's not a problem. And then other places, it is a problem in that when you're dealing with a 72-hour window, you don't have always the time to efficiently get from one part of the Commonwealth to the other, depending on where it is that you're processing that service. And so the bottom line basically on the bill here is that this is supposed to be a streamlined process. I worked with Chip Dix in regards to the amended version of this, which has the basically after line 28, where it says, provided that the submitter provides a statement that any such copy is a true copy of the original, by making sure that we are having that claim at the end, that the person has to sign their name to it, it's more or less at that point allowing of a fax to happen in an efficient, streamlined form.
Would it be better to use the word, rather than submitter provides a statement, say the submitter certifies, instead of provides a statement, that
Sure.
any such copy is a true copy? Wouldn't that be better, Steve? Yeah, but I think lawyers understand the word certify. The certificate of service type of thing. Yeah.
I think all the patron wants is to make sure that, in that last line, that the submitter of this copy simply writes out a statement, not necessarily under oath, that it comports with the original. With that said, this bill just seems to be so logical. Some jurisdictions now are accepting it, others are not. It's within our bailiwick to say, wait a second, this is going to be the law with all the jurisdictions, that you either accept a copy or you don't.
Yeah, Mr. Chair.
Yeah, Senator Peterson.
I think there's only 3 people in the state that care about this issue, and unfortunately, at least 2 of them are right here.
The third's my constituent, right.
And yeah, it is supposed to be an original certificate that's filed, and I've challenged certificates that were not original and had them struck. And that's an old lawyer's trick, okay? But I guess I don't have a problem with this. I'm curious, if you provide a statement, then does the statement have to be an original that the proof of service is a copy? It's kind of like it becomes a funhouse mirror.
Yeah.
I mean, most pleadings, whether it's a complaint, an answer, it's always the sworn pleading. The original is filed with the clerk, unless you have online like we have in the federal system. Now, having said that, I do tend to kind of lean towards you, Danica. At the end of the day, I don't know. I'm going to let my left-wing conscience here.
I'm just thinking lawyers' use of the term certify, this certificate of service. Provides
Mr. Chairman, you're right. It does, if you require certification, that has a more substantive meaning in that, and it doesn't have to be under oath, you're
No.
certifying something. If you falsely certify it, then you're susceptible to a perjury conviction. So it adds a gravity to it that may be appropriate.
So, Mr. Chairman.
Yeah, Mr. Chairman, I'm not sure that's a friendly amendment, because if we say it's under penalty of perjury, then we got to put a $50,000 impact statement on.
Well, no,
And
we're not
so,
saying
to
that.
answer your question, Mr. Chairman, that's probably not something that the patron would want to do.
Mr. Chairman.
That's my sound legal advice.
Yeah, Senator Chapin.
Yes, Mr. Chairman. So it seems that the inference would be that if somebody can certify that it is an original, a copy of an original, they've seen the original. They've had it in their hands. They know it's there. So I'm wondering why we couldn't add a line amendment that the original would be forwarded to the court. I mean, we're talking about having something that could be faxed to the court is what we're talking about, or something that could be emailed to the court, I presume.
Yeah.
So why couldn't the original then be returned to the court?
Well, that would add another.
And the original is returned to the court.
Well,
It's
that-
got to be out there, or how do they certify it?
Well, I think that would make it just add another layer of difficulty, seems to me.
Well, Mr. Chairman, I mean, how can you certify something if you've not seen the original, unless you know it is the original?
Well, it says the clerk shall accept a photocopy or other copy of the original as if it were the original, provides the submitter.
Mr. Chair.
Yeah. Go ahead, Senator
Peterson.
Peterson.
If you change the word from submitter to proponent, at that point, the proponent is the person that by definition has knowledge of the situation.
exactly.
So I would, Scott, let me talk. I would change the word submitter to proponent, in which case that kind of puts it back on the person that's propounding that this is a true copy of the original. And that being the case, I wouldn't have a problem with it.
I would consider that a friendly amendment, Mr.
So if
Chairman.
I'll move that
The
amendment.
proponent, what does it say, provided that the
Proponent instead of submitter.
Line 27.
promoter
Proponent instead of submitter.
provides a statement?
Right. Everything else is the same.
Mr. Chairman.
Can I get a second to my motion?
Well, yes, go ahead, Senator Serval.
I mean, here's the problem with this. We're kind of turning the rules of evidence on its head here, because a copy can only be certified by the custodian who has it in their custody. And, or another, just say somebody's going to attest in court that that's a copy of the piece of paper, they had to have the original in their hand. Now, basically, I think what this is saying is that maybe some person's going to stick it in a fax machine with a statement on the bottom saying that the copy I'm faxing you is an original, or the copy I'm putting in the mail to you. I mean, if the person who's certifying it, why don't they just send the original by mail or by FedEx?
It's a time factor, I think.
Yeah, well, Mr. Chairman, what's going on here is that a lot of the world has moved on to electronic filing. And some of these process servers are used to filing electronically in some places, and they're getting irritated. They still have to walk to the courthouse. It takes them time and money, and they want to keep their fees down. They don't want to have to build that into their process serving costs. So now they're trying to create some system where they don't have to walk to a courthouse anymore. And you know, but in terms of, I'm not clear who's certifying the copy if.
The propounding part. Can I get there's been a second to my motion. Can there be a vote on my motion, on my amendment?
There's
Right.
a second. I
Is there a
second.
second? All right.
I
Go
think, Mr. Chair, it's line
Yeah.
27, simply substitute the word
Proponent
proponent.
for submitter.
For submitter.
And you want to keep it just to provide a statement?
Yes, that's
Isn't
fine.
that the same as certifies?
John, just have a vote on
Is it
the
or not?
amendment, please.
Question, is it, Steve?
It's not the same.
Not the same? All right.
But, Mr. Chairman, the patron does not want the word certified.
Okay. All right, the motion is to change the word submitter to proponent. Is that right? All
Yes,
in
sir.
favor of the motion, say aye.
Aye.
All opposed, no.
And then I move to report the bill as amended.
Any further discussion? All in favor of the motion?
Mr. Chairman, can I just ask one more question? Like,
One, only one.
it's not clear to me that this solves the problem. The way I read it, the person who's certifying the copy has to be an original signature. So, you know, I don't know how you interpret this if I'm a judge. The person that's certifying the copy has to be a wet signature, the way I read this.
No, it just,
You can submit a copy.
submit a copy and say this is the original. Okay.
Mr. Chairman.
Yeah, Senator Morrissey.
Delegate Rome, I like the bill because it makes things efficient.
Right.
Somebody who is serving these services might do 50 in 5 different jurisdictions in Northern
That's right.
Virginia. Doesn't want to go to 5 different courts. He wants to get it, stay at his office, and submit it electronically. I don't have any problem with that person providing a statement that it's a true copy. I think we can assuage Senator Serval's concerns with the following. There may come a time where somebody is challenging that document. That still won't prevent that attorney from subpoenaing in the person that served the paperwork, subpoenaing the person who allegedly received it. So I don't, respectfully, I would tell Senator Serval, I don't see the angst that he sees here, and I would support reporting this bill.
The rules of the Supreme Court of Virginia allow for service by facsimile anyway.
Beg your
Right.
pardon?
The rules of the Supreme Court allow service of pleadings by facsimile. Okay, all right. Then it's moved and seconded that the bill as amended be reported. House Bill 780 be reported. All in favor vote aye. All opposed vote no.
Come on, Senator Stewart, this is home cooking.
Okay.
Ayes 10, noes 3, 2 abstentions.
10-3 and 2. Congratulations. The bill is reported. as amended.
All right, thank you, Mr. Chairman. Thank you to the members of the committee. Appreciate it.
Okay. Now, the next person is Delegate Heretic again. You're back again. You should have done your others when we.
Mr. Chairman.
They were earlier.
House Bill 436 is hopefully a technical fix to a problem that's been pointed up to be by a number of J&DR judges who seem to be irritated with it. This particular section, members of the committee, deals with what's required in a child custody child custody proceeding. And Section 20-146.20 requires that certain information be provided to the court in terms of identifying information about the child, and it's to be provided in the form of a pleading or an affidavit. Skipping down to subsection E of that section, basically it provides that if in a pleading or affidavit there is contention that the child or another party's it might be endangered by public disclosure to another party by providing that identifying information, the court then will take up by advising the court in the pleading or affidavit, the court can then take it up and to make a determination within 15 days. The problem is this. At the very end of E, the beginning of subparagraph E, it says, if a party alleges in an affidavit or a pleading under oath the health, safety, or liberty of a party or child shall be jeopardized, etc. Then it provides further on that such hearing on the determination and written finding on the issue shall be made by the court within 15 days of the filing of a pleading. All this bill seeks to do is add the words "or affidavit" at the very end of that section to make it a parallel construction and to get the local J&D judges off of my back.
Off your back. So their concern is what?
They want to add the words "or affidavit" at the end of that section. So it says pleading or affidavit, which is parallel construction with every other phrase in the statute.
Oh, I see. What difference does it make?
Well, the contention, Mr. Chairman, is this. The judges believe that a lot of these things are initiated by pro se litigants who do not offer pleadings as an attorney would.
Yeah, go ahead. Well, just a minute. I want to hear the answer first.
Well, and so when a pro se litigant offers this by affidavit, under the statute as it's currently written, it does not trigger the 15 days that the court has to make a determination. That triggering event is only by offering a pleading. So by offering a pleading or affidavit, it simply parallels everything else, and we can all go to dinner.
Okay, get them off your back. It's been moved and seconded to report Senate Bill 436. All in favor of the motion, vote aye. All opposed, vote no.
Thank you, Mr. Chairman. Members.
Okay.
That's 15-0.
It sneaks in 15-0. Congratulations. Okay. Delegate Myers. What bill do you have here?
This is HB 65.
Okay, HB 65.
Correct.
Okay. Missing Child with Autism Alert Program. Okay.
Correct. This is would basically create or allow the creation of a program for local, regional, statewide notification of a missing child with autism. A little unique than what we normally see, but if you deal with those in the autism community, one of the challenges they have actually had, it was if you're in the Northern Virginia area, it made the news there. A 12-year-old child with autism wandered off from a birthday party, and one of the things, the challenges is oftentimes if you go to a child with autism and you ask them, are you lost, are you in danger, they won't, they'll simply say, no, I'm fine. And so it's one of the things, the unique challenges. So working with the autism community. So that's basically the background of this bill, and it basically empowered the Virginia State Police to deliver the policies for the establishment of kind of a uniform standards. But again, this was something we've already seen up in the DC area, and happy to answer any questions.
Okay, any questions of the patron? Is there somebody speaking in favor of it?
Mr. Chairman, members of the committee, Randy Pearson on behalf of Autism Speaks. We support the bill and hope you'll act favorably upon it. Thank you very much.
Okay, any questions?
Mr.
Anybody
Chair,
opposed to it? Yes, Senator
Is this
Peterson.
is this a budget amendment? Is there any budget money for this?
Remember, there was no fiscal impact.
No fiscal impact?
Fiscal.
No,
Oh, it's gonna be
no
good.
fiscal
It's gonna
impact.
go by. He wants to go by. Okay. Okay, it's been moved and seconded that the bill be reported. All in favor of the motion, vote aye. All opposed, vote no.
Ayes 15-0.
15-0. Congratulations. Thank you very much.
Thank you, sir.
Senate Bill 1225 by Delegate Jeff Campbell to be dealing with judicial assistance. He asked that it go by for the day. Without objection. What else we got to do? 331. Okay, Senator Delegate Hope's definition of incapacitated person, particular diagnosis. House Bill 331 of Delegate Hope's go by for the day without objection. Okay? Anything else? Well, thank you. The meeting's adjourned. The committee will rise. Thank you very, very much. We got out of here pretty